Good morning, everybody. Welcome to the Rocky Mountain ADA Center's virtual workshop presentation of ADA 101 Mastering the Basics. My name is Jessica Lucania. I'm the instructional designer here at the Rocky Mountain ADA Center, and I will be your moderator for today's webinar. I am a Latina woman in her 30s with dark brown eyes and dark brown medium length hair. I am wearing a black and white floral blouse, and my Zoom background includes a colorful blue with our center's logo on the top corner. Real-time captioning is provided for this webinar. The caption screen can be accessed by choosing the caption icon in the meeting control toolbar. During this session, only speakers will have audio. If you do not have sound capabilities on your computer or prefer to listen by phone, dial 1-719-359-4580 or 1-669-444-9171. You can use the webinar ID 915-4216-9452, and the passcode is 615472. Please note that this is not a toll-free number. This webinar qualifies for Certified Rehabilitation Counselor, CRC, Continuing Education Units, Society of Human Resource Management, SHRM, recertification credit, and credit towards the ADA Coordinator Training Certificate Program, ACT-CP, which is administered by the Great Plains ADA Center. If you need a training certificate for credits or simply because you want one, you must send an email with your full name to email@rockymountainada.org. We will only be sending certificates upon request. Should you experience any technical difficulties during the webinar, please send a private chat message to the host by typing it in the chat window. Type your comment in the text box and then hit enter. For keyboard-only users, use Alt-H to access the text box. Or if you prefer, you can email at email@rockymountainada.org or call 719-444-0268. And that's voice and relay. Today's webinar is titled ADA 101 Mastering the Basics, and will cover a broad overview of a number of ADA topics. After today's 4-hour workshop, you should be equipped with entry-level knowledge of the Americans with Disabilities Act, ADA. Several registrants submitted questions about very nuanced ADA topics. We will not be able to go into those in great depth today, but we encourage you anyway to contact the ADA National Network if you continue to have any other question after today's webinar. Our slides and a recording of today's webinar will be made available on the event page for this webinar on our website within the next few business days. We do have one planned 15-minute break during the middle of today's webinar. We're going to be covering a lot of information today, and we encourage you to submit your questions as soon as you have them, and we will pause periodically to address them. If there's time at the conclusion of today's session, we will be happy to answer any additional questions that you might have. You may submit your questions in the Q&A text box using the Q&A button on the meeting control toolbar. If you are listening by phone and are not logged into the webinar, you may ask questions by emailing them to email@rockymountainada.org. In addition to myself, we have 3 speakers from the Rocky Mountain ADA Center who will be presenting in today's workshop. Emily Schumann, our center's director, Maggie Sims, the center's project manager, and Chris Murphy, our knowledge translation specialist. And with that, I will turn it over to our very first presenter, Emily.
All right, well, thank you so much, Jess. Once again, my name's Emily Schumann. I'm the director over here at the Rocky Mountain ADA Center. Really happy to have you all with us today to dive into this ADA 101 session and just get to know about the ADA and this broad high-level overview. So if we could go to the next slide. And I'll describe myself as well. So I'm a white woman in her mid-30s. I have long blonde hair. I'm wearing a black top, and I'm presenting against a green background. So we do always need to include just this little bit of a disclaimer, which is just to let you know that all of the information that you're getting today should be considered informal guidance rather than a determination of your legal rights or formal legal advice. We're not a law firm. We're just an informational technical assistance center that's available as part of the ADA National Network to help everyone understand their rights and responsibilities under the ADA. We are operated by the University of Northern Colorado in Greeley, Colorado, and we are funded by the National Institute on Disability, Independent Living, and Rehabilitation Research. Next slide. So for anyone who's not already familiar with the ADA National Network, the Rocky Mountain ADA Center is part of that network. We're one of 10 centers whose mission it is to provide information, training, and technical assistance to anybody who wants to understand their rights and responsibilities under the ADA. Our region covers Colorado, Utah, Wyoming, North Dakota, South Dakota, and Montana. But there is a regional center that covers every state in the nation. And what's really great about the national network is that we all share one central 800 number. So anytime you have a question about the ADA, all you need to do is call 1-800-949-4232, and you will reach your regional ADA center based on your phone number. Of course, you can also visit adata.org in order to find your regional center. So for people who are not familiar with these ADA centers, we do provide a variety of services, such as technical assistance, that's those answers to questions, referral and networking. So we do connect with many of the other disability organizations throughout the country, enforcing agencies, things like that. We do a lot of research around implementation of the ADA and barriers to implementation. We provide training as you're all getting today. We do publish and share quite a number of materials. And of course, we have a large social media presence. So please do find and connect with us on your individual favorite social media platform. And so I see we're getting some comments about speakers not being shown on Zoom. So let's see, Patricia, would you be able to help figure that out? I'll pause while we see if we can.
Sure, I'm going to go ahead and pin you, Emily, just to see if that will help.
So we can pin the speakers, but then that seems to take away the spotlight for interpreters. So people who need interpreters may need to pin the interpreters for themselves. I'm not sure. And thank you everyone for bearing with us while we figure this out. Okay, I've added a spotlight. So now I think we're both pinned and spotlighted. And I would love if someone could just chime in and let me know if you can see me now. Okay, okay, I think we figured it out. All right, so we'll make sure to do that for each speaker. Now, okay, great, I'm getting that feedback. We can see both the interpreter and Emily. Okay, perfect. Thank you all for bearing with us and for letting us fix that for you. Okay, so let's go to the next slide. So just to give you some background on the ADA, how we got to the ADA, it's important to understand a little bit of the legislative timeline. So the modern disability rights movement really kicked off after the 1964 passage of the Civil Rights Act, which provided a lot of civil rights protections, but did not include disability. So in 1968, you had the Architectural Barriers Act, which allowed for accessibility in federal buildings, followed by the Rehabilitation Act in 1973. And in the 1975, the Individuals with Disabilities in Education Act, or IDEA, was passed. In 1976, we had the Higher Education Act Amendment, which added the inclusion of students with disabilities. In 1986, we have the Air Carrier Access Act, which applies to accessibility in air travel. In 1988, we have the Fair Housing Amendments Act, which added protections for people with disabilities in housing. And then in 1990, we have the passage of the Americans with Disabilities Act. So when it comes to laws that protect people with disabilities, the ADA has the distinction of being one of the more comprehensive civil rights laws for people with disabilities, but as you can see, it's actually one of the newest laws. So there's still a lot of misinformation and struggles with compliance. So again, that's part of why we're here today, is to hopefully demystify the ADA somewhat and help you all understand both rights and responsibilities. And so in 2008, the ADA was actually amended, and I'll just talk briefly here in a moment about what that amendment included. But first, one of the big moments that led up to the passage of the ADA was March 12th of 1990, just a few months before the ADA was passed. It had been introduced into Congress, but at that point, it was pretty certain that the lawmakers were going to stall on passing the bill if people with disabilities didn't make a strong statement as to the need for a civil rights law of their own. So to symbolize the barriers confronting disabled people, more than 60 activists abandoned their crutches, wheelchairs, power chairs, and other mobility assistance devices and began crawling up the stone steps that lead to the US Capitol building. So in this picture, you see an 8-year-old crawling up the stairs. She's wearing a red and white bandana. Her name is Jennifer Keelan. As I mentioned, she was 8 years old at the time. She has cerebral palsy, and she famously declared, "I'll take all night if I have to." And so this is a really powerful moment that illustrates, how needed the Oh, I'm sorry, Jessica, I forgot to mention, if you could please go to the next slide. So now we're on the right slide. So this picture shows Jennifer Keelan, and so she's powerfully declared, "I'll take all night if I have to." And this demonstration really motivated lawmakers to finally pass the Americans with Disabilities Act. Next slide, please. All right, so fast forward to July of 1990, July 26, 1990, President George H.W. Bush signed the Americans with Disabilities Act, or the ADA, into law. And the ADA is a civil rights law that affirms the inherent dignity of people with disabilities in America. As a civil rights law, it prohibits discrimination against people with disabilities in most areas of public life, including jobs, schools, transportation, public and private places that are open to the general public. And the purpose of the law is to really make sure that people with disabilities have the same rights and opportunities as everyone else. So the law gives civil rights protections to people with disabilities and guarantees equal opportunity in public accommodations. The ADA is divided into 5 titles, which I'll mention here shortly, and we'll dive into some of those titles as we go along today that relate to different areas of public life. The ADA, we always say, is descriptive, not prescriptive, which means that it really doesn't enumerate or prescribe exactly what to do in every single situation. It simply could not have been as comprehensive as it is if it had to predict, the changes in our language and technology and try to figure out every possible situation that a person with a disability might face. So instead, the law is descriptive. So really, it just describes the goal of non-discrimination and what that should look like. But it allows for some flexibility for how to achieve that non-discrimination. So we see it really as a positive that it's got that broad nature. My apologies, I was just pinning the other interpreter. Okay, so it's got that really broad nature, which allows for, broad application of the law. And so, the law was really just designed to be applied on a case-by-case basis. And so we often say there's no one-size-fits-all solution. And for this reason, you'll often hear us say, it depends. I see some questions coming in, and a lot of times, sort of the first answer we might give is it depends, because it is always applicable on that case-by-case basis. And so sometimes we need some additional information or need to know some more factors in order to figure out how the law applies in that situation. Next slide. So it's important to note that the ADA is not affirmative action or an entitlement program. When we talk about the ADA, we talk a lot about equal access, which is also known as equity. So it's really important to understand how equity and equality differ. A lot of people think that the goal is equality, but really the goal is equity. So when people are treated exactly the same or identically without considering their individual needs, that accomplishes equality, but it usually doesn't accomplish equal opportunity. So we know that some people will still have to work much harder to participate in society, and some people might even be left out entirely. So on the other hand, equity means that we are going to account for those social differences so that everyone can have equal access. So equal access does not necessarily guarantee identical outcomes. So the goal really is to just remove the barriers that people with disabilities face in order to give them a fair shot at participating in society. So again, the ADA is not about financial gains or handouts. It's not about special privileges. It's simply about equity. And to recap, equality is where everyone gets the same thing, and equity is where everyone gets what they need. Next slide. So the ADA is divided into 5 main sections, which are called titles. You could also think of them as chapters. And so your entity may have obligations under multiple titles, and we'll talk more about each title as we go along. If you're an individual with a disability, you will be protected by all of these titles, and which again we will discuss more in depth as we continue on. So generally speaking, Title I applies to employment. Title II applies to state and local. Title III applies to private entities, both for-profit and nonprofit. Title IV is called the telecommunications title, and then Title V is miscellaneous. And I'll dig into those a little bit more here shortly. Next slide. So protected by the ADA, of course, a person has to qualify as a person with a disability. That means that they have to have a disability as defined by the ADA. So we really have to start by understanding what does it mean to have a disability under the ADA. Next slide. So it's important to context of the ADA, disability is a legal term rather than a medical one. So because it's a legal definition, the ADA's definition of disability is different from how disability might be defined under some other laws, such as, for example, Social Security disability benefits. So when the law was first passed, lawyers really tried to narrow down, a classification of who is qualified as disabled and who isn't. And there was, a lot of to, you know, choose specific conditions or diagnoses that were or were not disabilities. So to remedy that, that's when we actually saw the passage of the ADA Amendments Act in 2008. And the purpose of that was really to clarify that the ADA's purpose was not to narrow down the definition of disability, but to the abilities and whether or not they were receiving equal opportunities. So with that, the ADA defines a person with a disability as someone who has a physical or mental impairment that substantially, okay, I'm hearing some connection issues. Hopefully that's getting better. Okay. So the ADA defines a person with a disability as someone who has a physical or mental impairment that substantially limits one or more major life activities. And it's also a three-pronged definition that includes people who have a record of such an impairment, even if they do not currently have a disability. Like, for example, somebody who has cancer that is now in remission. The definition also includes people who don't have a disability but are regarded by others as having a disability. For example, someone who may no longer be, who may have some physical differences, maybe scarring, but they're not actually limited in any way. So again, the definition of disability under the ADA is a three-pronged definition. It includes people who currently have a disability, impairment, but these are not, this is not an and definition, it's an or definition. So in other words, you don't have to meet all three prongs to be qualified as a person with a disability. You just need to meet one of these prongs. Next slide. Okay, so I'm still getting reports that my sound is breaking up. I apologize for that. I'm not sure what I can do with that. Perhaps I can turn my video off and see if that helps. Let's give that a try. Okay, so I want to break down the definition of disability just a little bit further for you. So an impairment is going to include a wide variety of things, anything from physical conditions, intellectual or cognitive conditions, psychiatric conditions, sensory conditions, and of course, many other types of disabilities are included in the ADA's definition of impairment. What an impairment does not include under the ADA's definition of disability is simple physical characteristics, things like being blonde or having freckles, normal deviations in height, weight, or strength, common personality traits, environmental, cultural, or economic disadvantages. And then there are some certain sexual and behavioral disorders that are specifically called out in the ADA that are exempt from being considered impairments. That's things like kleptomania, compulsive gambling, pyromania, things like that. Next slide. Okay, so when we say an impairment substantially limits a major life activity, this does not mean that it has to completely prevent or restrict a person from being able to perform the major life activity. And it's really just an assessment that's compared to most people in the general population. And we're always looking at this using a common sense analysis and without scientific or medical evidence. We're not putting people through rigorous testing to determine whether their condition substantially limits a major life activity. And a disability can also be episodic, meaning that, something like epilepsy, for example, may come and go. And so a person with epilepsy might not be substantially limited constantly, but when they do have those episodic seizures, they become more substantially limited, which still qualifies them under the ADA's definition of disability. So nonetheless, it's important to note that not every impairment will constitute a disability. So another important note here is that the determination of whether an impairment substantially limits a major life activity should also be made without regard to the positive effects of mitigating measures. So for example, if someone has a condition that qualifies as a disability, but they can take medicine that alleviates the symptoms of that condition, it does not mean that they no longer qualify as a person with a disability. They could still be considered an individual with a disability despite the fact that they take medicine that alleviates their symptoms. So of course, as you'll learn with the ADA, there's always an exception. The only mitigating measure that is taken into consideration is eyeglasses. And so if the use of ordinary corrective lenses results in no substantial limitation to a major life activity, then the person's vision impairment does not constitute a disability under the ADA's definition. Next slide. All right, so a major life activity. So remember, we talked about you have to have an impairment that substantially limits a major life activity. A major life activity is something that most people in the general population can perform with little or no difficulty. These are things that include, but are certainly not limited to working, speaking, breathing, doing manual tasks, walking, seeing, self-care, hearing, and learning. Your major bodily functions are also included as major life activities. So of course, that's going to include things like functions of your immune system, normal cell growth, digestive system, neurological system, respiratory, circulatory, reproductive systems, all of those major bodily functions. And the determination as to whether a particular condition impacts a major life activity must be always, again, made on that case-by-case basis. We know that two people with the same medical diagnosis often have different experiences and may or may not be limited in different ways. So an impairment that substantially limits one major life activity does not need to limit other major life activities to be considered a substantially limiting impairment. Next slide. So the ADA provides a couple of additional protections. And the first one here is a protection around exercising one's rights. So this means that people with disabilities cannot be retaliated against or coerced or otherwise have their ability to exercise their rights under the law interfered with. These are considered distinct forms of discrimination under the ADA. And so the ADA does add this protection. So when an individual exercises their rights under the ADA, things like filing a complaint or requesting an accommodation, those actions are considered protected activities. Next slide. The ADA also has a provision that protects people from discrimination whether or not they have a disability because of their known relationship or association with a person with a known disability. So this means, for example, that an employer is prohibited from making an adverse employment decision based on unfounded concerns about the known disability of a family member or anyone else with whom the employee has a relationship or association. The ADA does not require that it's a family relationship to be protected under this association provision. The key is just whether the entity is motivated by the individual's relationship with or association with a person who has a disability. And really the purpose of this association provision is to prevent entities from taking adverse actions based on those unfounded stereotypes and assumptions about people who associate with people with disabilities. So it makes it unlawful to do things like refusing to hire an individual who has a child with a disability based on the assumption that the applicant might be away from work excessively or be otherwise unreliable. Next slide. Okay, so now that we've defined disability and understand who's protected by the ADA, always really important to understand the prevalence of disability in the country. So the Centers for Disease Control and Prevention report that right now there's about 61 million adults in the United States that have a disability. That's about 26% of the population. And breaking that down even further, we know that about 13.7% of adults in America have difficulty walking or climbing stairs. 10.8% of adults in America have serious cognition difficulties. 5.9% of adults in America are deaf or have serious difficulty hearing. And 4.6% of adults in America are blind or have serious difficulty seeing. Next slide. So we always look at disability as a distinct identity. And it's always, one of the big things that we can tell people is that disability is an identity that anybody can gain at any time. It's usually not a question of if, but more often when and how. Of course, we know that accidents happen and most of us will experience a change in ability as we age. So we are all more likely than not to either have a disability at some point in our lives, or at least know and love someone with a disability. People with disabilities actually make up the largest minority group in the country and in the world. But even still, we believe that the reported numbers of disability are likely lower than the reality. This could be because people whose disabilities are invisible might choose to keep that identity private. A person may understand that they have a medical condition, but not actually identify as disabled. Sometimes people experience a lack of medical access that leads to being misdiagnosed or underdiagnosed. And of course, sometimes people are simply hesitant to identify themselves or express their identity as disabled because of a fear of being stereotyped or stigmatized. So one way to view disabilities is as the product of an inaccessible world, not a product of an individual's conditions and limitations. And this is also known as the social model of disability. The social model of disability suggests that if environments were constructed in a way that was accessible for people with disabilities, those individuals would not be restricted from full participation in the world around them. So in other words, the social model looks at disability not as a limitation of the self, but actually a limitation of the environment. And the social model of disability most closely aligns with the ADA because it's all about creating a more accessible world than expecting people with disabilities to adapt to an inaccessible world. And we believe that, the more people who understand their rights and responsibilities under the ADA and the importance of the law, the more we'll be able to foster voluntary compliance and therefore create a more inclusive society. Next slide. So now that we know who has rights under the ADA, let's talk real briefly about who has responsibilities of non-discrimination under the ADA. And I'm just going to again, be very brief, just discussing the 5 titles, and my co-presenters today are going to dive more deeply into the 3 main titles as we go along. So next slide. So Title I of the ADA, as I mentioned, is the employment title. It applies to employers that have 15 or more employees, including part-time employees, as well as state and local governments employers, regardless of their sizes. And the ADA defines an employee as anyone who works for an American company, their subsidiary, or any firm controlled by Americans outside of the USA. And so Title I of the ADA prohibits discrimination on the basis of disability in recruiting, hiring, promotion, training, pay, and a whole bunch of other aspects of employment. Disability discrimination occurs when an employer treats a qualified individual with a disability unfavorably because of their disability. And I know Maggie's going to go much more in depth into Title I here shortly. So this title of the ADA is enforced by the Equal Employment Opportunity Commission, or the EEOC. Next slide. So Title II of the ADA applies to state and local governments, their departments, and their agencies. Really, as you'll see throughout the ADA, this title, generally speaking, prohibits discrimination against people with disabilities in all programs, activities, and services that are offered by that state or local government. Title II also establishes the standards for the operation of public transit systems, including commuter and intercity rail, for example, Amtrak, and is enforced by the U.S. Department of Justice. So you will know if you're part of a state and local government organization, but it's important to know that if you receive any state funding at your organization, you also have to follow the Title II requirements. Next slide. So Title III of the ADA, very similar to Title II. Title III applies to places of public accommodation, which are broadly defined as most businesses or buildings that offer certain goods or services to the general public, both for-profit and nonprofit. And again, it prohibits discrimination on the basis of disability in the provision of goods and services to people with disabilities in those places of public accommodation, and is also enforced by the U.S. Department of Justice. Next slide. Title IV, we're not going to dig too deeply into Titles 4 or 5 during today's webinar, but I will just let you know that Title IV ensures that individuals with hearing or speech disabilities have equal access to telecommunication services. It mandates the establishment of telecommunication relay services that allow people to communicate by telephone through relay operators or text-based systems. Title IV also requires the inclusion of closed captioning on public service announcements, and it requires that emergency services, including 911, are accessible to people with disabilities through the use of text telephones, or TTYs, and other communication options for reporting emergencies. And Title IV is enforced by the FCC. Next slide. And finally, we have Title V, which is that miscellaneous chapter. It primarily addresses different miscellaneous provisions related to the broader act. So it allows for the use of alternative dispute resolution, like mediation, to resolve ADA-related disputes. It also outlines provisions for allowing prevailing parties in ADA cases to recover attorney's fees and costs. And it also authorizes the Attorney General to issue regulations and guidance to clarify and enforce the ADA, and allows for technical amendments for proper implementation and interpretation. And it also does establish a statute of limitation for filing ADA claims, which generally requires that for Titles 2 and 3, claims be filed within 2 years after the alleged violation. However, that can be extended to 3 years for cases involving claims of intentional discrimination. And for employment discrimination claims, a person usually must file a charge with the EEOC within 180 days from the date of discrimination. And Title 5, this miscellaneous title, really just serves to provide additional legal and procedural details that support the effective implementation and enforcement of the ADA's overarching goals, which are, of course, to promote equal access and opportunities for people with disabilities. Next slide. So we've got a few minutes to take a couple of questions now. We will, as Jess mentioned, pause for questions periodically as we go along. So I've seen some questions come through. Jess, do you have any questions that you want to point out?
Yes, there's a two-part question that was sent in earlier.
Okay. It says, I would like to know what you have to say about ADA Title II and reasonable modification. I recently called the Department of Justice hotline and was told ADA Title II is only about fundamental alteration. However, in some guidance about ADA Title II, I see a mention of undue financial and administrative burden in addition to fundamental alteration. So that's a great question. I will, let's save that one for when Chris does his presentation on Title II. He's going to dig into some of those defenses and exemptions that you've mentioned there. Somebody asked, are we allowed to print and share these slides? Yes, absolutely, please do. We will be sending out a recording of today's session after the presentation, as well as the slides. So you will have access to those, and you're more than welcome to share them, distribute them, use them however you like. So someone asked, do VA Veterans Administration's related disabilities qualify automatically for the ADA? And then reference the 30, 40, 80, or 100% disability percentages. So this is the first time I'm going to use that phrase, it depends. So those two systems define disability are very different. So again, the ADA just defines disability as a physical or mental disability that substantially limits major life activity. So it's just going to depend on how your individual conditions impact your ability to perform those major life activities. I would go so far as to say probably in most cases, if you are plugged into the VA disability system, you're probably going to have protections under the ADA. The ADA is meant to be broad and provide protection to as many people as possible.
We have a couple of other questions if we still have time, Emily.
We have time for maybe one more question.
Okay, we have a question that says, when is it required for CC, I'm guessing that's closed captioning, for example, a Zoom meeting for an HOA during COVID?
Yeah, that's another great question. So we're going to talk a little bit about effective communication throughout today's session. So it would be required when somebody with a disability specifically requests that that's known as an auxiliary aid or service. So it's something that you can certainly provide proactively for anybody who might need that. We always encourage people to go above and beyond the ADA. But for something like a public meeting, you would want to provide, that effective communication service upon request. Now, HOA, so that's housing, which the ADA will talk more about. That's one of the areas that the ADA does not apply. So I would actually refer you to look into the Fair Housing Act, which would be the applicable law, kind of a companion law to the ADA. So with that, just so that we stay on time, I'd like to go to the next slide, Jess, and turn it over to Maggie.
Good morning, everyone. Thank you so much for being here. My name is Maggie Sims, and I am going to talk about employment this morning. I am a white female of a more mature age, wearing glasses, and I have a blue clothing on and a blue background. I will turn off the video because it seemed that it was working better when Emily turned off her video. So sorry that we have to do that, but I want to be sure everyone has access. So I will turn off my video. Next slide. So Title I, as Emily mentioned, is about employment. And just in general, it's all about equality. We can hire, fire, promote the most qualified, deserving individual. It may be a person with a disability, it may not, but it's the person who is the most deserving, just like any other employment opportunity. There is a general rule: an employer is not required to hire or retain an individual who is not qualified to perform that job. And we'll talk a little more in detail about exactly what it means to be qualified. Next slide, please. So in the employment area of the ADA, employment discrimination means that it's unlawful to discriminate against a qualified individual with a disability regarding all aspects of the employment phases. So the job application process. So when you think about that, you need to remember that if this is done online, it needs to be sure that it's accessible. It's in the hiring process, promotion, the discharge, compensation. Can employees get to, again, things that may be online? Is it accessible to everyone? What about the benefits? Any of the training that is provided for employees? And again, just all aspects of employment. Next slide. So under this Title I, who has responsibilities? It does apply to private employers who have 15 or more employees. It is all state and local government entities because they are considered to have always have more than 15 employees. It applies to employment agencies, labor unions, joint labor management committees. And if you contract out, it also it does not negate your responsibilities as the employer. So remember that, again, you always will have some type of a responsibility under Title I of the ADA. Next slide. Who is protected? And Emily went over the ADA's definition of what a person with a disability is. under Title I, there's another part to that. It has to be a person who is considered qualified individual with a disability. So under Title I, what that means is that the individual must satisfy the skill, the experience, the education, and all other job-related requirements that is required for the particular position that they're being looked at for the position for the employee as an employee. So can they perform the essential functions of the position with or without reasonable accommodation? And this just means that we, as an employer, we must consider everyone regardless. Do they need an accommodation? As long as they can perform it with or without that accommodation, they are qualified. Next slide. What are the essential functions of the job? Sometimes this gets kind of confusing, but you know, basically it's the fundamental job duties of that position. It's what they're hired for to do. It does not include what's called marginal or peripheral functions that someone else may be able to do. And the essential functions, what it needs to do is specify what needs to be done and not necessarily how. This is where we get confused sometimes, is that we have in mind that a job has to be done a certain way. What's important is that it gets done. And so we have to look outside that box to see there can be different ways of how it's done. And this is what we want to keep in mind. Next slide. The hallmark to me of Title I is the reasonable accommodation requirements under the ADA. And basically, what is an accommodation? It is a modification or an adjustment to a job, the employment practice, or the work environment. And it makes it possible for an individual with a disability to have that equal employment opportunity. An equal employment opportunity means it's the opportunity to attain the same level of performance or to enjoy equal benefits and privileges of employment. So that's basically what we're talking about. It gives the opportunity that if a person is an employee or an applicant, they have the same opportunity to for that job position as anyone else. Next slide. When are accommodations required? Again, throughout that whole process. And so you want to look at, as an employer, the application process. Is it accessible? Many things today are done online, and these may get overlooked. And so you want to be sure that there is it's accessible if it is online, or that there are possibly alternatives if someone is not able to fill out an application online. What are some other options that they may have? It's also required for the performance of the essential functions of the specific position that they're being hired to do. This can take on many forms, and we'll talk a little bit more about that. It's also required for the enjoyment of equal benefits and the privileges of employment. This can be something as simple as maybe you're having a holiday party. Have you also considered that wherever this is going to take place, is it accessible? If you have an employee in a wheelchair, or if there are going to be announcements made, are there interpreters or captionings for those who may have hearing loss? So it applies to every part of the employment experience. Next slide. These are the basics for the accommodation process. It must be an effective accommodation. What does that mean? Well, and in number 2, we see it does not necessarily have to be the best accommodation, and it may not even be exactly what the employee has requested. It has to be effective, though. So sometimes an employee may request a particular type of accommodation. And again, depending on what it is, and you will hear that word so much, it depends. It's going to depend on the situation, the individual, case by case, everything. It has to be looked at individually. It must only reduce those employment-related barriers. And again, sometimes everything, there's always a little nuance to things. But in general, the accommodation is for employment-related barriers. In general, personal devices are not required to be provided by the employer. For example, a hearing aid or a wheelchair, glasses, things like that. But the employer is certainly not prevented from providing extra accommodations. The ADA is minimum standards, and an employer can do anything they want to do. So you can go above and beyond. That is up to you as the employer. Remember that this information must be kept confidential. When somebody discloses that they have a disability, this is information that should only be shared with the appropriate offices or individuals, not coworkers. And you need a strategy on this for when maybe a coworker asks, why does this individual get to bring their service, or they may not even say service animal. Why do they have this dog with them in the workplace? You've got to be able to answer that without revealing that a person has a disability. So it does take some pre-planning and strategies that are going on. Next slide. There are some responsibilities on the employee. And in general, the employee must initiate this reasonable accommodation process. That means they have to, in general, approach the employer and disclose that they do have a disability and that they need an accommodation. You never have to disclose until you need an accommodation, but you do have to disclose that once an accommodation is made. Many times a disability is invisible, and so an employer does have the right to request documentation for the need of that accommodation. And so be prepared. If you're a person with a disability, you may need to provide this. And as an employer, what you want is just enough information to determine that there is a disability and that there is a need for accommodation. So it's kind of just get what you need to start the process and no more. The employee also needs to be involved in helping to identify an effective accommodation. You know, many times an employee, this is new. They've just been diagnosed with something, a new impairment. So it's all new, and they're discovering too what it is they need. And so it's important on both sides that the employee have some options and some ideas of what may be able to accommodate them in their job, and be open to that this is a process of determining between the employer and the employee of what will work for everyone. And there's some great resources, and we'll talk about those later today as well. Next slide, please. The ADA uses the word reasonable. It needs to be a reasonable accommodation. And of course, that's again where it depends comes in. What is reasonable for one situation, one company, one individual may not be reasonable in another situation. And so this is something that each time it's case by case, and we want to take it into account. But the Equal Employment Opportunity Commission, the EEOC, which is the enforcing agency for the employment provisions of the ADA, has determined that there are some accommodations that are almost always going to be reasonable. And some of these would be making modifications to increase the facility accessibility. And so if you have an inaccessible building, what can we do? There are different ways to determine how to make it accessible. It can be a physical change. It can be moving a particular office, things like that. These need to be taken into account. It can be job restructuring. You can restructure in many different ways. It can be flexible scheduling. It can be acquiring new equipment, providing qualified readers and interpreters when needed, modifications of application and testing procedures and training materials. So these are usually going to be reasonable. And remember, again, the key is that we look at each request case by case and see what we can find. Next slide. The EEOC has also determined a few things that is generally never going to be considered reasonable. And so one is eliminating an essential job function. A person who is hired to do the essential functions, that's their job. And in general, you never have to eliminate an essential job function, keeping in mind that there are marginal or peripheral functions that can be redesignated. At least that needs to be considered. You do not have to lower production standards that is applied to all employees. Again, not providing personal use items. You do not have to excuse the violation of a uniformly applied conduct rules. If, and we'll talk more about undue hardship, but if an employer determines that something is an undue hardship, keeping in mind that even when something is an undue hardship, we still need to look further to see what may not be an undue hardship. Changing a supervisor. The ADA, the EEOC has determined in general, you do not have to change a supervisor as an accommodation, but it may be that that supervisor may need to look at altering their way of doing things or interactions or things like that. There can be a change in the way something is done. And so that's pretty significant. We get that question a lot. Next slide. The interactive process is so important. And on both parties need to be involved in this. What you want to do when we begin the interactive process, somebody has told you that I have a disability and I am requesting an accommodation. So what we're going to do then is look at the particular job, determine what are the essential functions of this particular job. Consult with the employee about what the abilities are and what are the limitations. It's okay to discuss this with the individual. They're going to know the best about what their disability may need. And of course, the employer will then, you'll take this into consideration to determine how do we accommodate that. But it's okay to talk with them. You can consult with that employee to help identify potential accommodations and also to assess effectiveness. As we mentioned before, an accommodation does not always have to be the best or even the first requested, but it does have to be effective for the individual. It is always best to consider the preference of the employee. So if I come to you and I say, I have this disability and here is my request for accommodation, it's okay to look into it and see, are there other options? But when you can, try to really use the preference of the employee because they know what is best for them. And then you're going to select the accommodation that best addresses the needs of the employee and the employer. So it's a two-way street. It's a two-way street, and sometimes we forget that. Next slide. So some of the process steps for the interactive process. Go ahead, Jess. There are, and you can go ahead and put all those up if you would. For the interactive process, the steps you want to take, number one, recognize. That sounds simple. There are no magic words. So the ADA doesn't require that an employee say, I request reasonable accommodation. I am going to disclose. That's just not required. And so you have to train your personnel, your supervisors, whoever works with your employees to understand and recognize that this may be a request for accommodation. It can be as simple as saying, gosh, I'm having real issues with my back and the chair that I'm sitting in. You know, a supervisor, whoever they're talking to at this point, you want to pay attention to this. Don't ignore it. It may be a request for accommodation. It may not, but that's the interactive process. So pay attention. At that point, then you're going to gather the relevant information that's needed. Number one, if you do need medical documentation, you can request that. In general, if a person's disability is obvious, so a person, say, is in a wheelchair and they've requested, you know, a larger or a higher desk, I mean, you really don't need to get medical documentation for that. It's a little different if it is invisible. So again, get what you need to determine that and determine an effective accommodation. Then you're going to explore. So let's look at the available options. There, again, this is where you're going to discuss this with the employee. They're going to give you some ideas and thoughts. The employer can take those, and they have to look at what, you know, what the issues are in the particular job position, the particular facility, things like that. So it is this process. Then there are some great resources, Job Accommodation Network, which I refer a lot to them. They have some great options. And this, again, is keeping in mind that some disabilities are, some people are new to disabilities, and so they're also learning as well. And then you're going to choose what that is, what's reasonable, and what is effective. And then implement that. So that may be new equipment, it may be modifications, and give the employee acclimation to the new environment. And then I lost my last one. Monitor. And so it's okay to check back, make sure that it's working, maintained, and communicate. It's okay and important to keep those open lines of communication. Next slide, please. Some possible defenses is two of them under Title I, undue hardship and direct threat. Next slide. Undue hardship is an action that causes significant difficulty or expense to provide, and there are some ways to determine this, and go ahead and put those up. These are all ways to help determine what is a significant difficulty or expense to provide. There are many things to look at, and it will, again, depend and be determined on each individual organization, employer, and situation. Next slide. And then direct threat. And what that is a significant risk of substantial harm to the health or safety of the individual or to others. And an employer, the important thing about this is, go ahead, Jess, if you would. The employer may not simply assume that a threat exists. You must look at this again, case by case. That has to be established. There has to be a specific risk. It must be current, and it must be assessed on a case-by-case basis. Next slide. Remember, please, these determinations are a process. And if it is a direct threat or an undue hardship, you must now take that extra step to try and identify another accommodation that doesn't pose a direct threat or undue hardship. So the process doesn't end even if these things are determined. We need to look at other options at that point. Next slide. All right, questions?
You've got some great questions that came in, Maggie. Okay, so how do you recommend a person with a disability notify a potential employer that they have a disability and the need for a reasonable accommodation? And also, what happens if they become employed and then the disability presents itself later, and then later on they need accommodations?
Great questions. And to some degree, it depends. You do not have to disclose that you have a disability until you need an accommodation. So until you need that, you don't have to notify the potential employer. If you can honestly answer, they can ask you, can you perform this job with or without an accommodation? And you know that you can do the essential functions with an accommodation. You are legally allowed to answer yes. At the point that they offer you a job position, at that point, now we can discuss specific accommodations that may be needed, if indeed they are needed. And so at that point, the employer should take into consideration your request for accommodation, and they cannot take back the job offer because they are now informed that they have to provide or need to provide an accommodation. And so each individual has to determine what they feel is the best way to do that. But the ADA does not require that you disclose it until you need it. Now, if you need an accommodation, say for the application process or the interview process, so before they've offered you a job position, then of course you will have to disclose at that point. If you have a vision loss and you need large print or something along those lines, or you're deaf and you need an interpreter for the interview, obviously you'll have to disclose ahead of time. And so it is an individual decision, but know that the ADA says until you've been offered that job position, and you do not have to disclose and until you need that accommodation. And then and I'm sorry, the second part of that, where did it go?
It was if after you're already employed and then a disability comes up, what happens then?
Yes, and this is very, very common. You know, as we mentioned earlier, the odds of everyone having some type of a disability are greatly enhanced. And so this is very common. And you know, at that point, if you do find out that I've just been diagnosed with MS, or, you know, cancer, and I'm going to need some time off, at that point, that's when you go and discuss it. And each employer the ADA doesn't prescribe exactly how an employer responds or has a process to determine this, other than, of course, that they go through this interactive process and that they take it on a case-by-case basis. And so it's good to know if your employer, do they have a process in place? And that can simply be, we have a form that you fill out and you return it to. Sometimes it's your direct supervisor, sometimes it's directly to HR. So it can vary from place to place, employer to employer. So, but you do want to participate in how they have that set up. But again, and you know, one person may have a disability and they request an accommodation, and then they've been working there for 5 years, and now there's another impairment that substantially limits their life, and they need to ask for another accommodation completely different from the first one. It is an ongoing responsibility on behalf of the employer, and so you are not limited on when you can ask for an accommodation, or if there are additional accommodations that you need as time goes on.
Great, and I'll just do one more quick question, Maggie, and everybody's asked a ton of great questions, so we'll try to continue answering those. We'll type answers in and hopefully get to some of them at the end as well. So last question for you. Being told the accommodation is denied because, quote, if we allow that,
Yes.
other employers would want the same, or, quote, how can we allow that for you and not others? Or it isn't fair to other employees. Are those allowed reasons to deny accommodations?
Great question. And they absolutely are not reasons to deny an accommodation. And EEOC expressly discusses this particular situation. One accommodation is that we modify, an employer can modify their policies, practices, and procedures. So it's okay to have a policy. An employer can have a policy that says you cannot, you know, employees cannot work from home. You must work from the office. That's okay. You can have that. But if I am now a person with a disability, I am now asking this as an accommodation. And at that point, the employer needs to look at it individually and determine, again, what is effective and what's going to work for both of us. So it absolutely is not a legitimate reason to deny it. So you'd want to know why it was denied.
All right. Well, I think we can go on to the next slide and turn it over to Chris.
Good morning or good early afternoon, everybody. My name is Chris Murphy. I'm a male in my late 30s with dark hair and dark eyes. And I do want to self-identify as a person with a disability. My left arm is partially paralyzed, and that's from a birth injury. It's called brachial plexus palsy or Erb's palsy. So with that, I'm also going to turn off my camera just to ensure that the audio quality is adequate. So today we'll be talking about Title II of the ADA, which applies to state and local government. Next slide, please. So as you know by now, the ADA is a civil rights law. Title II of the ADA is meant to enable people with disabilities to be provided equitable opportunities to participate in and benefit from the programs, services, and activities of a state or local government. It applies to all state and local governments, their departments and agencies, and any other instrumentalities or special purpose districts of state or local governments. Next slide. So we've already gone over the definition of a disability. It's the same Title II. It's a physical or mental impairment that substantially limits a major life activity, having a record of an impairment or being regarded as having a disability. The definition of disability should be construed broadly in favor of expansive coverage to the maximum extent permitted. And an impairment is a disability when the meaning of this part it substantially limits an ability of an individual to perform a major life activity as compared to most people in the general population. Unlike Title I of the ADA, Title II does not generally permit verification of by a physician that you have a disability. Generally speaking, credible verbal assurance and observed behavior are essentially the thresholds for providing proof of a disability to participate in programs of a Title II entity. Next slide, please. So the Title II of the ADA frequently references the phrase a qualified individual with a disability. Next slide, Jess. Yep, thank you. A qualified individual with a disability. In this context, the qualification isn't meant to apply to the disability itself, having a qualifying disability, as much as it is to apply to being qualified to participate in the program itself. It's the same qualifications as any person without a disability that's also expected to have in order to participate in the program. If a program requires that a participant be of a certain age, such as applying for a driver's license, and a person with a disability meets that requirement, that person should be considered a qualified person with a disability. Another example could be to possess prerequisite skills, such as being able to swim if someone's interested in a river kayaking program. If the ability to swim is a required skill for the program, and any person either with or without a disability does not know how to swim, then that person would not qualify for that program. Next slide, please. So the ADA prohibits discrimination on the basis of disability to any qualified individual with a disability in participating in or benefiting from benefits of the services, programs, or activities of a public entity, or by being subject to discrimination by any public entity. Taking our previous example of a prospective kayaker, denying them the opportunity to participate on the basis that they use a wheelchair and the assumption that they cannot swim is discrimination. Many people who use wheelchairs can swim. If the program requires participants to be able to swim and a wheelchair user can swim, that person should have the opportunity to participate. Next slide, please. So the ADA Title II requires a public entity to make reasonable modifications to its policies, practices, and procedures when necessary to avoid discrimination on the basis of disability. This is subject to limitation if the entity can demonstrate how making such a modification would fundamentally alter the service, program, or activity involved. I'll take a minute to address a previous question. Specifically, when you look at the ADA Title II, undue financial and administrative burden are really only specifically found under program access and communications. Typically, a reasonable modification to policy, practice, and procedure is modifying a way that something is done. It typically doesn't involve a cost to it. So that's just a broad answer to that question. But of course, just like anything within the ADA, it really depends on what the request is. If the request involves an auxiliary aid or service, we'd have to look at those regulations to determine, what the responsibilities are. So just as a broad answer to that question, I hope that's satisfied, and we can talk about that in more detail later if necessary. So in cases where the presence of a disability is not obvious, the person with a disability may need to share at least some information about their functional limitations that they're experiencing in order for the entity to make a reasonable determination of what modifications are appropriate. Remember that Title II of the ADA does not give a public entity the right to access current medical conditions of participants in programs. Public entity can't require a doctor's note to determine reasonable modifications. Credible verbal assurance, observed behavior are the thresholds. Right, next slide, please. A public entity cannot impose or apply eligibility criteria that screens out or tend to screen out individuals with a disability or any class of individuals with disabilities from full and equally enjoying any service, program, or activity, unless such criteria can be shown to be necessary for the provision of the service, program, or activity. An example could be requiring a driver's license as proof of age. There are many people who cannot drive due to their disability. People who are blind or have low vision, people who have epilepsy. So requiring a driver's license for identification or verification of age is not in line with the ADA's eligibility criteria. You can have state ID requirements, but driver's license would not be fulfilling that. Next slide, please. A public entity is also required to administer services, programs, and activities in the most integrated setting appropriate. What's the opposite of integration? It's segregation. This goes back to the ADA being a civil rights law, which was modeled after the Civil Rights Act. People with disabilities have historically and systematically been segregated from society, not of their own free will. And the aim of the ADA is to rectify that practice moving forward. Essentially, the most integrated setting appropriate should be interpreted as the most integrated setting possible. Next slide, please. A Title II entity may not place a surcharge on an individual or group of people with disabilities to cover the cost of measures taken to provide equitable treatment. This can include auxiliary aids and services, such as sign language interpreting services or large print material. So you cannot charge a person for the extras that they may need to participate equally. Next slide, please. A public entity may impose legitimate safety requirements necessary for safe operation of its services, programs, and activities. However, the public entity must ensure that its safety requirements are based on actual risks and not on mere speculation, stereotypes, or generalizations about individuals with disabilities. Next slide, please. A public entity is required to maintain an operable working condition accessible the accessible features that it provides. Temporary or isolated interruptions in service or access due to maintenance or repairs are inevitable, and they are okay. There is no concrete time period for operation or usability to be restored, but it should always be initiated within a reasonable time frame at the very least. This could apply to snow removal or broken elevators. In each case, it's up to the public entity to decide how it wants to fulfill its obligation under the ADA. It's not reasonable to presume a city can remove snow from all public sidewalks after a snowstorm, but it may choose to remove snow from public sidewalks that serve public facilities and programs. Broken sidewalks from tree roots can also trigger the accessible pedestrian right-of-way to be repaired under this section. Elevators should usually be up and running within a few days of breakdown. Next slide, please. A public entity is not required to provide personal devices such as wheelchairs, prescription eyeglasses, or hearing aids, or services of a personal nature, which include assistance in eating, toileting, or dressing. A public entity is also generally not expected to push a wheelchair user at their request. This could be subject to a reasonable modification, which we spoke about earlier, in the setting of, let's say, a county hospital where it's a normal expectation for staff to push people in wheelchairs, whether they qualify for the ADA or not, as a disabled person. In that context, it might be reasonable because that's a normal thing that they do. But if you're going to, let's say, City Hall or the county courthouse, that's generally not something that they would do. So it's generally not a service that would be considered reasonable in that context. It would actually be considered a fundamental alteration of what they do. Next slide, please. A public entity is not required to permit an individual with that participates in the services, programs, activities of the public entity when that individual poses a direct threat to the health and safety of others. In determining whether an individual poses a direct threat to the health and safety of others, public entity must make an individualized assessment based on reasonable judgment that relies on current medical knowledge or the best available objective evidence to ascertain the nature, duration, and severity of the risk to others, the probability that the potential injury will actually occur, and whether reasonable modifications of policies, practices, or procedures or the provision of auxiliary aids and services can mitigate that risk. So there's a whole slew of this procedures that they have to do before they can make a final determination that yes, that is a direct threat. Next slide, please. So program accessibility. Program access is possibly the biggest obligation a public entity has under Title II of the ADA. Program access provides that no qualified individual with a disability should, because the entity's facilities are inaccessible, be excluded from participation from services, programs, or activities, or be subject to discrimination by that entity. Next slide, please. The ADA requires a public entity to operate each service, program, or activity so that when viewed in its entirety, programs are readily accessible to and usable by individuals with disabilities. This doesn't necessarily mean that every single location needs to be fully accessible. What it means is that every program offered needs to be accessible, and that public entities do have options when it comes to how they ensure that programs are accessible. Next slide, please. Some of the methods that are permitted under program access to provide accessibility to the programs are redesign or acquisition of equipment, relocation of programs to accessible facilities, assignment of aids to beneficiaries, home visits, delivery of services at alternate accessible sites, alteration of existing facilities and construction of new facilities, the use of accessible rolling stock or other conveyances, and any other method that are all possible choices a public entity can make, so as long as they result in equitable access to the programs of the entity for people with disabilities. A public entity is not required to make structural changes in existing facilities where other methods are effective in achieving the goal of equitable access to programs. A public entity is required to give priority to methods that achieve program access in the most integrated setting appropriate. Next slide, please. Public entities are required to take appropriate steps to ensure that communication with applicants, participants, members of the public, and companions with disabilities are as effective as communications with others. The ADA requires public entities to, provide auxiliary aids and services to make sure that individuals with speech, hearing, and vision disabilities can understand what is said, written, and can communicate effectively. Effective communication rules also apply to companions, such as family members or friends who have disabilities. Next slide, please. So the type of auxiliary aid or service necessary to ensure effective communication will vary in accordance with the method of communication used by the individual. The nature, the length, the complexity of the communication involved, and the context in which the communication is taking place. In determining what type of auxiliary aid or service are necessary, a public entity is required to give primary consideration to the request of the individual with a disability. This is unless an equally effective means is available or would otherwise impose an undue burden. In order to be effective, though, auxiliary aids and services must be provided in accessible formats in a timely manner and in such a way as to protect the privacy and independence of the individual with the disability. Next slide, please. Here's some examples of common auxiliary aids and services. Qualified sign language interpreters, either in person or through video remote interpreting services. Note takers, exchange of written notes could be potential. Real-time caption or real-time computer-aided transcription services, written materials. There's just a lot that can be considered an effective way to communicate and provide an auxiliary aid or service to an individual with a disability. And again, it really depends on what is usable to that person. An example is if you just blanketly provide a American Sign Language interpreter to people who are hard of hearing, without understanding that maybe an individual lost their hearing recently later in life, they might not understand American Sign Language. So that's just not an effective way to communicate to that person. Another method would be more productive and really should be based on what that person requests. Next slide, please. I mentioned sign language interpreting. So a qualified interpreter means an interpreter who is able to interpret effectively, accurately, and impartially, both receptively and expressively, and using any necessary specialized vocabulary for the conversation. This can be through on-site appearances or by video remote interpreting services. Certified doesn't necessarily mean qualified. So that's a really important thing to understand when it comes to qualified interpreting. A public entity should not require an individual with a disability to bring another individual to interpret for him or her, or place a surcharge on that individual for the interpreting services. Accompanying individuals, including children, should not be used to interpret except in cases of emergency. It's a very narrow window when that is permitted. Next slide, please. So if VRI is chosen as the method to provide effective communication, it must satisfy these 4 requirements: real-time, full motion video and audio over a dedicated high-speed, wide bandwidth video connection, or a wireless connection that delivers high-quality video images that do not produce lag, choppy, blurry, or grainy images, or irregular pauses in communication. A sharply delineated image that is large enough to display the interpreter's face, arms, hands, and fingers, and the participating individual's face, arms, hands, and fingers, regardless of his or her body position. Must be clear, audible transmission of voices, and adequate training to ensure that users of the technology and others involved, so that it can just be done quickly and effectively to set up and operate the VRI services. Next slide. So all state and local governments are required to comply with Title II of the ADA. When a Title II entity employs 50 or more people, it's required to designate an employee with the responsibility to ensure that the entity is complying with Title II of the ADA. Part-time and seasonal employees do count towards the 50 employee minimum. This employee is generally referred to as the ADA coordinator. The ADA coordinator's responsibility includes accepting, investigating, and resolving grievances of non-compliance with the ADA. The public entity is required to make the name, office address, and telephone number of the ADA coordinator available to interested persons. Along with designating an ADA coordinator, a public entity that employs 50 or more people is required to adopt and publish grievance procedures, providing for prompt and equitable resolution of complaints, which allege any action that would be prohibited by Title II of the ADA. And next slide, please. And then public entities should all have conducted a self-evaluation of their practices, services, policies within a year of the passage of the ADA to ensure that the public entity is complying with the requirements of Title II. This should be a living document as new and or revised services, policies, and practices are implemented continually. When a public entity employs 50 or more people and structural changes are necessary to make programs accessible, a transition plan should be developed. The transition plan requires consultation with people, with interested parties, including people with disabilities. The transition plan should be made available for public inspection and public comment, and which should use to help shape the plan itself. The transition plan is required to identify all the physical obstacles in the public entity's facilities that limit the accessibility of its programs or activities to individuals with disabilities. It's required to describe in detail the methods that will be used to make the facilities accessible. It's required to specify the schedule for steps taken to achieve compliance and indicate the official responsible for implementation of the plan. And the last little bit of information is that technically January 26th of 1995 was the deadline to accomplish this. All new facilities in theory should have been designed fully accessible. Since then, planned alterations should have been improved in the physical access of existing facilities. The reality is that many municipalities have not done this, and it's been a long time. January 26, 1995 was quite a while ago. So that's the take home with that. It's long overdue for that to have been done. So I think defense is potentially saying that, oh, we don't have the money to do that. It may not hold up if you frame it as, so you've had 30 years to figure that out. So with that, let's open it up to some questions.
Okay, so we've got a couple minutes for questions. Chris, there's lots of people are looking for more information around some of those defenses. So one question says, can you talk about what fundamental alteration and or undue financial and administrative burden might look like in terms of establishing it as a reason for denial?
We can talk about that broadly, but I don't want to get too far into the weeds because, again, we're not necessarily a legal resource for that kind of determination. Generally speaking, a fundamental alteration would just be that's not just something that just isn't the way things are done. I'm trying to think of an example. That would be an easier. What's that?
Oh, I was just going to say, like, maybe asking for delivery of goods and services to your home when that's not something we normally provide as a state and local government. Would that be an example?
That would depend. If if the program was inaccessible due to the facilities of the entity, that might be an acceptable method to achieve program access to make a home delivery. But if the entity's facilities are fully accessible and the individual otherwise can't accomplish that, that could be a fundamental alteration. So it sort of depends.
It always depends. And I'll take this moment to remind everybody, please reach out to your local ADA center with your questions. If we aren't able to get to them today, a lot of times there's a lot of complexities that we need to talk through with you in order to give you the best answer.
Yeah,
So how about this one? Go ahead.
Oh, I just want to address the question about
Yeah.
financial burden. That conceptually could be harder to be a defense as we're getting further away from that date of January 26th of 1995. Think about if a person with a disability is discriminated against because of an inaccessible facility, for example, and that community tries to say, well, we don't have the money to install a ramp, and that goes to federal mediation. It could be that the mediator looks at this case and says, well, you've had coming up on 30 years as your deadline. You've 28 years, almost 29 years to figure this out. I don't understand how you couldn't figure out how to install a ramp in the last 29 years. So that could be a harder defense because that deadline was so long ago and because new facilities should have been built with the ADA in mind since then. So just keep that in mind.
Great. And in 30 seconds or less, can you answer, do hospitals fall under Title II? And should the ADA coordinator person at a hospital help with the grievance process?
If the hospital is a department of a city or a county or another state or local government, then yes, it would fall under Title II. The ADA coordinator should have a hand in ensuring that the hospital, in that case, is complying with Title II of the ADA. Whether or not the hospital itself should have an ADA coordinator, it probably should, because that person would be more familiar with the intricate workings of that specific facility. But if they don't, it would definitely go up the chain of command, and whether it's the city or the county, that ADA coordinator should have some responsibility to ensure that the entity is meeting its responsibilities.
Great, thank you. All right, let's move on to the next section.
Hi, this will be Title III Public Accommodations, and this is Maggie again. I'll start out and then Chris will finish up. Next slide, please. Next slide. Chris just finished talking about Title II, which are your what's called public entities, state and local governments. So Title III under this section refers to public accommodations. And what this means, basically, these are privately owned businesses, companies, whether they are for-profit or nonprofit. And there's a technical definition of that. A public accommodation affects commerce. Basically, they own, operate, lease to. And then this list of what would be considered different types of public accommodations. So again, very broad: commercial facilities such as office buildings, warehouses, education, courses and exams, entertainment, recreation, food and drink, such as restaurants, lodging. There are a couple of exceptions, but transient lodging is covered under Title III, except where it is owner occupied and have fewer than 6 rooms. Sales and service facilities such as clothing, financial, hair salons, legal, medical, travel, all of these. Social services such as daycare, food banks, senior centers, shelters. These are usually going to fall under Title III, but many do fall under Title II, as the question we had about the hospital. A hospital can fall under both Title II or one or the other, I'm sorry, under Title II or Title III, determining on who owns them and who manages and who operates that particular hospital. Next slide. This also includes, and this is not a complete list. Again, everything depends, but this is going to include adoption agencies, daycare centers, homeless shelters, again, depending on who owns and manages it, art galleries, museums, bowling alleys, hotels, motels, non-public schools. So what that would mean would be a private school. This can be a preschool, elementary, it can be postgraduate, undergraduate. These would be privately owned and managed and not a Title II school. It's offices of accountants, attorneys, healthcare providers, hospitals. It also includes public transportation terminals, and Chris will talk a little bit more about that. But keep in mind that airlines themselves, the airplanes, do not fall under the ADA. They do fall under another law called the Air Carrier Access Act. So again, depends on which law may cover that. Restaurants and bars, theaters, concert halls, and stadiums. Again, very broad application here. Next slide. There are some exemptions specific to the ADA. When it was written, they did exempt what's called a private membership club. And there's a specific definition. These are they require a special membership fee. It's very limited as to who can be a part of it. And so again, it depends on what that might be. It does include religious entities. They are exempt. So these would be churches, temples, mosques, anything that is owned, managed, and operated by a religious entity. The federal government is actually not covered under the ADA. They are covered under other laws, one in particular, the Rehab Act, and Congress is covered under the ADA. Just a little nuance there. Housing is not covered under the ADA. It is covered under the Fair Housing Act. And so you do have to determine the correct law to know where to proceed if you're having issues. The ADA does not cover, in general, Native American tribes as they are a sovereign nation. Next slide. The highlights of Title III, very similar to Title II for state and local governments, but the highlights are that businesses do have to provide auxiliary aids and or services to provide effective communications for those who may have hearing loss, vision loss, speech disabilities. They have to have an equal opportunity to participate, and that's where auxiliary aids or modifications may come in. Equivalent transportation must be provided. The whole goal of the ADA is integration, so that we don't put someone with a disability into a separate area. We want them to be integrated as much as possible. The other highlight of Title III is that a business needs to look at doing readily achievable barrier removal. Chris will talk more about that. And when this is not possible, we need to look at alternatives. And so that can be something as simple as going out to meet an individual at their car because there is a ramp or a lack of a ramp that they can't get into the facility. And a very key part of this is reasonable modifications in policies, practices, and procedures. And this, again, it can be very broad. It means to make, maybe we have to change a policy that we have. And a good example of this is we may be a public accommodation and we don't allow pets or animals into the facility. But if I'm a person with a disability and I have a service animal, I am basically asking you to modify your policy, your no pets policy, to allow my service animal into the facility with me. So that's one easy example. Next slide. Effective communication is very important. And, all customers and companions need to understand and fully understood what the conversation is, what's happening, what is being told to them. An important part of this is that this also applies to a companion. And so that means a family member, including a child, a friend, an associate. And so that has to be, effective communication has to be provided to them, even if they are not the direct, say, a patient. They are included in that effective communication. And this is provided in a number of different ways. It can be through auxiliary aids and services, which Chris covered, such as interpreters, large print, braille, things like that. It's a very wide range of services and devices. And it will vary from situation to situation, person to person, using some of the things that Chris mentioned, such as what is the context of the conversation? Are we talking about a medical situation? What is the complexity? Is there a lot of information that has to be relayed? How important is this to the individual's life? What is the length of the meeting and the conversation going on, and the number of people that are involved? When you have more than one or two people, you have some issues that the individual may not be able to decipher who is saying what and at what time. So these are things that you would take into account each time. Next slide. Examples of auxiliary aids and services for deaf and hard of hearing individuals can be what's called CART, computer aided transcription services. This is real-time captioning, which we have today. It can be exchange of written notes, again, to taking into determining the issues that we mentioned before. How long is this? Is there technical language being used? Is this a basic request for directions? So this can be acceptable at different times. Open and closed captioning are other forms. Qualified interpreters, as Chris went into detail, very important that they are qualified, not necessarily certified. And sometimes that is a state requirement. So you do want to look at that. But the ADA requires that that interpreter that is used is effective for the individual. You can also use video phones, which are great. We've heard of VRS, video relay services, VRI, video relay interpreting. Lots of great flexibility with those. For those who may be blind or low vision, audio recordings may be the most accessible format for them. They may use braille materials. Not everyone who is blind uses braille, so you do make an individualized assessment. Large print, a qualified reader, which is basically the same thing as a sign language interpreter. They're qualified to read, which it has some quite a few nuances to it. It's not just a matter of reading. A person with a speech disability, it could be a screen reader, it could be a TTY, which is a teletext typewriter. Again, and these are just a few examples. Next slide. Qualified interpreter, that is very specific. They need to be able to interpret effectively, accurately, and impartially. Very important here. They are able to sign or fingerspell what is being said. That's the expressive portion. And then they need to be able to voice what is being signed or fingerspelled, which is the receptive portion of that. So in other words, it's not just for the deaf individual, it is also for the hearing individual. Are they able to understand what is being requested of them from the deaf customer? Keep in mind, there are many sign language systems. American Sign Language is one form of sign language. Signed English, signed exact English. There are a number, and that's why it's so important to work with the individual each time. There is specialized vocabulary. Not all interpreters know all things, and so you may have a medical interpreter. They know the medical signs. Legal interpreters for the legal interpretation. Educational interpreters also. Excuse me. You may not require a customer to provide their own interpreter. This is generally not going to ever be allowed. Go ahead, Jess. This would include friends or relatives. Say, if I'm with my deaf son, I am not usually going to be a qualified interpreter. And so you can't require the family member to do that, or someone with a personal relationship. Because many times they have difficulty being impartial. Think about a medical situation where you've got a parent or a spouse, and they're involved much more than just trying to relay information. Or they may have a contrary interest. That's important too. And this can violate rights to confidentiality. Next slide. The important thing too, as I mentioned before, certification under the ADA is not required, but many states have taken it a step further and do require certain types of certification. So check with your states as well. Next slide. Just some interesting information. Only 10% of people in the US who are blind or have low vision use Braille. So it's not necessarily effective in all situations. And it's okay to ask an individual. It's not required if there's some other effective means available, like audio, something like that. Large print, sighted, commonly use 8 to 12 font. That's what we normally use. It's suggested that for low vision, you use 16 or larger, and sans serif, such as Arial font. Next slide. And this is also, again, an important part of Title III, policies, practices, and procedures, reasonable modifications. It's just a different way of doing things. It generally doesn't even involve a cost to doing it. It is limited by if it is a fundamental alteration. Next slide.
Hi,
And
Maggie. This is Chris. I think I'll
yeah.
take over from here, if that's okay.
Sure.
All right. Well, thank you. It's Chris again. So readily achievable barrier removal is what public accommodations are required to do. Public accommodations must remove architectural barriers and communication barriers that are structural in nature in existing facilities when it's readily achievable to do so. Architectural barriers are physical elements of a facility that impede access by people with disabilities, and a single step can be an insurmountable barrier for a wheelchair user, as an example. So can a heavy door, a toilet stall without grab bars, or not providing tactile signage. Next slide, please. So in order to remove physical access barriers, a place of public accommodation needs to identify where those barriers exist within their facility. This is done by using the 2010 standards as the benchmark for minimum physical accessibility. The covered entity for Title III would need to find areas of their facilities within their control that do not meet the criteria of the 2010 standards. Areas not under control of a business would not be the responsibility of that business to address the accessibility thereof. An example would be a shared parking lot or a lobby of a multi-tenant office building or a shopping center. The accessibility would be of the landlord. The responsibility would be for the landlord or the property manager in that case for those shared spaces, but not necessarily the individual businesses. There are a number of resources available to assist a covered entity with this process. The U.S. Access Board has several great guides which explain individual aspects of the standards. Also, the New England ADA Center has created checklists for existing facilities to guide someone through the process who may not have a lot of experience with physical access. The ADA Center, the Rocky Mountain ADA Center, can also provide detailed technical assistance. We can walk you through the process, answer your questions that may come up along the way. We also have training specifically aimed at introducing the basics of barrier removal for small business. Accessibility consulting firms also exist. They are kind of expensive, so I'd always recommend going the free route first, which would be contacting your local ADA Center. Next slide, please. So what does readily achievable mean? I mentioned that earlier. Readily achievable means without much difficulty or expense. So it's going to mean different things to different entities. Next slide, please. Installing a ramp to access a franchise of a national chain might be well within what's considered readily achievable for that entity. But installing a ramp to access a new independent bookstore might not, just because their financial resources are just so vastly different. The things to take into consideration in determining what readily achievable means are the nature and costs of the action. Sometimes the physical nature of the barrier has no viable solution, like if there's not enough physical space to install a ramp in the first place. Other times, the solution may be too expensive for the business to cope with. The ADA will not require the business to perform an action that would threaten the financial stability of that business. Unique aspects of the site and any relationships to a parent company could also influence the determination of what's readily achievable. An example could be an independent hardware store. They will have less resources than your local Lowe's or Home Depot, for example, which have a national franchise to rely on. Next slide, please. So a barrier that's identified that is not readily achievable today may be readily achievable at another point in the future. A new business leasing an existing facility might not have the financial resources to add a ramp into their business when they open. However, barrier removal is a continuing obligation. In several years, that business may be very successful in earning, a decent profit. When that business could earn enough profit to reasonably save capital to invest back into the business, addressing the ramp at that time could be readily achievable. Next slide, please. Tax incentives exist within the IRS code to help alleviate some of the costs for businesses and small businesses, especially in their efforts to comply with Title III of the ADA. A tax credit is available to businesses that have total revenues of $1 million or less in the previous tax year, or 30 or fewer full-time employees. This credit can cover 50% of the eligible access expenditures in a year up to $10,250 with a maximum credit of $5,000. The tax credit can be used to offset the costs of undertaking barrier removal and alterations to improve accessibility, improving accessible formats such as Braille, providing large print and audio tape, making available sign language interpreters or readers for customers, employees, or for purchasing certain adaptive equipment. Tax deductions are available to all businesses with a maximum deduction of $15,000 per year. The tax deduction can be claimed for expenses, including barrier removal and alterations. Since these incentives are built into the IRS tax code and not the ADA, further information should be sought by a qualified tax professional. Next slide, please. Here's some common examples of barrier removal. Not every barrier is made equally. Some barriers will be expensive to remove, while some will be really inexpensive or virtually free. Some will be somewhere in between. Being aware of the responsibility to remove access barriers and addressing low-hanging fruit is highly advised for all Title III covered entities. Really low-hanging fruit could be something like just making sure that your parking sign is hung at the appropriate height above the ground. Oftentimes you can just do that. It might be an inch off and you raise it an inch and then you're fine. Other examples are, installing ramps, making curb cuts, repositioning shelves, widening doors. There's a whole list. These are just examples and it's not exhaustive whatsoever. Next slide, please. There are priorities the DOJ has specified for consideration for physical access barrier removal on an existing facility. The first are site arrival points, the accessible route to get to the entrance and the entrance itself. This could be the parking lot or path starting at the public sidewalk, the path that leads to the front door, and the door itself should be able to get into the building in the first place. The second priority is to access the goods and services of the facility. This will be individualized to every entity, but people with disabilities should have the same access to goods and services as others without disabilities. The third access priority is to restroom facilities. This could be removing obstructing furniture or vending machines, widening doors, installing ramps, providing accessible signage, widening toilet stalls, or even just installing grab bars or repositioning grab bars at the correct height. And then the last priority by the DOJ is any other amenities provided to people in general, which one example could be drinking fountains. Next slide, please. Maintenance of accessible features also applies to Title III entities. One common example, all doors must have maneuvering clearances on both sides of the door. Toilets, sinks have clearances as well. These clearances should be maintained. Miscellaneous things should not be stored in these areas that the ADA requires to be kept clear. I see this all the time, especially in restrooms where the toilet stall clearance is used to store cleaning supplies. It's simply not providing equity to people with disabilities by putting things there. Another common clearance that's obstructed are placing trash cans in maneuvering clearances by the door to get out of a restroom. Maintaining the accessible route from site arrival points in the winter is another example of maintaining accessible features. Next slide, please. And because not all barriers are readily achievable to remove, the ADA does require that a covered entity to provide alternatives to barrier removal that are readily achievable so that people with disabilities do have access to the goods, services, and advantages of the place of public accommodation. Examples of providing include providing curb service or home delivery, if possibly, retrieving merchandise from inaccessible shelves or racks, and relocating activities to accessible locations where possible. So when the determination that barriers are not readily achievable to remove, the alternatives to barrier removal means you have to do something, or at least explore as many opportunities as you can until you run out of options. And with that, we'll have a couple minutes for questions on Title III.
Okay, so first question I have for you here is, Does an intercom at a business fall under ADA Title III? We have been discussing how it is not that accessible to the people with hearing loss.
It should be, yes. If it's provided to people in general, then it should be subject to the ADA.
Great. We have another question about parking. Is ADA parking required on a private street with ADA parking for a store that is open to the public?
It depends if the business owns, if the business owns that private area of the street and provides public parking, then conceivably, yes. But that's a little unique situation I've never really encountered before. So that might include some nuance that would be better for their discussion.
Okay, and I imagine we have the same sort of issue here, but the question is, are you able to expand on the ADA requirements for restrooms for those who have dwarfism, people of short stature who can't reach the sink, faucets, soap dispensers, paper towel dispensers?
Right. That is a very real barrier. Really what I can say is that the ADA standards were designed to meet the needs of 80% of people with disabilities. There's no way to accommodate all people with disabilities. And the ADA standards are essentially a compromise between accessibility for most people and what's reasonable to provide for a business. So that is a question when you're talking about just Title III facilities in general. I mean, as long as they're complying with the minimum standards, they're really in compliance with the ADA. But I do understand that that's not in keeping with really addressing everybody's physical access barriers.
Okay, so we've gotten a couple of questions about service animals. So I just want to assure everyone that we'll be talking about service animals after the break. And I think, excuse me, Chris, you might also address this after the break. Is there a special exemption for historical buildings? There are a couple of buildings downtown that do not have elevators. However, I know elevators are very expensive.
Right. Under Title III, that would fall, there's two things going on there. Readily achievable barrier removal. Most of the time, regardless if it's historic or not, adding an elevator is more than likely not going to fall under what's readily achievable because of the difficulty and expense associated with such. Now, historic buildings in general, they are required to be accessible, but the accessibility requirements are limited to where certain conditions are met. If the building must be registered with some sort of historic society or preservation list, and then when accessibility is considered, such as entrances, restrooms, and parking, that has to go through a process where a historic preservation officer has to sign off on, does the proposed alteration affect the historic significance of the facility or not? It could be just a gravel parking lot that's inaccessible, that has no actual historic significance. And then at that point, it's like, yeah, that there should be accessible parking added to that. But going back to your question specifically about elevators, that would just generally not be readily achievable because of that difficulty and expense component.
Okay, so I think we're gonna, if you'll go to the next slide, Jess, we'll go into our 15-minute break. So everybody can meet their own individual needs here for a little bit. We will start back up again at 11:30 Mountain Time. And so thank you all, and we'll speak again soon.
All right, everybody, I hope you had a really good break. We're going to resume the training session, and we're going to take it over to Miss Emily.
All right, thanks, Jess. Can you just confirm real quick that you can hear me?
Yes.
Okay, great. All right, so we're going to talk briefly about websites and the ADA. As with all of the various sections and topics that we're covering today, there's much more that we could always get into with these topics. So just remember that this is meant to be a high-level overview, and you're always more than welcome to contact either us or your local ADA center if you have more questions or want more information on these topics. So if you'll go to the next slide. So let's think about why website accessibility matters. Of course, we know that inaccessible web content means that people with disabilities are denied equal access to information. An inaccessible website can exclude people just as much as something like steps at an entrance to a physical location. So these really inaccessible websites can really present significant barriers for people with different types of disabilities. And as we all know, in recent years, a great number of services have moved exclusively online, and people really rely on websites like never before for, all aspects of daily living. So for example, think about access to voting information, finding up-to-date health and safety resources, looking up mass transit schedules, and fare information. All of these things have increasingly become more and more dependent on having access to websites. Not only that, but ensuring web accessibility for people with disabilities is a top priority for the Department of Justice, which is, as you know, one of the entities that enforces the ADA. Next slide. So the ways that websites are designed and set up can often create unnecessary barriers that make it difficult or impossible for people with disabilities to use websites. Just again, like design barriers in the physical, the physical space in facilities can prevent someone with disabilities from entering a building. So those barriers on the web keep people with disabilities from accessing information, but barriers can be prevented or removed so that websites are accessible to people with disabilities. Next slide. So in its current state, the ADA does not specifically address websites per se. Remember that the ADA was written in 1990 or passed in 1990, probably written in the couple of years before that. So at that time, there really wasn't as much, the internet was not nearly what it is today. So the ADA, in its current form, doesn't specifically address websites, but the Department of Justice has made it clear that state and local government websites, as well as business websites and programs, should be accessible. They look at websites as part of your programs and services. So, again, think of all of the things that, for example, state and local government entities allow citizens to do online these days, everything from applying for licenses, paying fines, all of that is integrated into those websites. So even though currently the ADA does not have a technical standard for ADA accessibility, we do have some best practices that we can point to. So in the absence of those ADA regulations and standards, we often look to Section 508 of the Rehabilitation Act, and especially the Web Content Accessibility Guidelines, also known as WCAG. As a best practice. It's also important as you think about accessibility in the digital environment to look at not just your websites, but also the accessibility of your documents, making sure those are accessible to screen readers. And understanding that there are things that you can do even when you're posting social media content to make it be more accessible. Things like making sure videos have captions, providing alternative text for images, and writing in plain language. And we do have, the Rocky Mountain ADA Center has additional training on all of these topics that you can access for free through our website. So just keep in mind that if you're curious to know more about social media accessibility, there is additional free training out there for you, and we'll be happy to refer you to that. Next slide. So I do have some breaking news for you. So I mentioned that the ADA in its current state does not address website accessibility. However, the Department of Justice did issue a notice of proposed rulemaking under Title II of the ADA that aims to improve website and mobile application or app access for people with disabilities. This would be an amendment to the ADA, would add enforceable standards that would cover web content, documents, and mobile applications. This amendment right now only applies to state and local governments, so those Title II entities. And this proposed rule would adopt the Web Content Accessibility Guidelines, or WCAG, version 2.1, level AA as the enforceable standards. So even though we don't have these enforceable standards under the ADA currently, this is definitely in the works. And I think it's something that we can all anticipate, being enforceable in the fairly near future. And this is it's a big milestone for the progress of the ADA. So I know I've referenced WCAG, those Web Content Accessibility Guidelines, a few times, and Jess, if you'll go to the next slide. So let me tell you a little bit more about those standards. So the Web Content Accessibility Guidelines is a set of guidelines to make the all websites, web content more accessible to people with disabilities. It helps to make sure that web pages and apps have proper organization, clear navigation structure, all kinds of things that go into these guidelines. And these are benefits not just for people with disabilities, but really for everyone. So the most recent version of the Web Content Accessibility Guidelines was actually published just recently in October of 2023 and are referred to now as WCAG 2.2. And so this is the next version beyond what most of us have for a long time been working with, which was WCAG 2.1. And so this is really an international set of guidelines that were developed by the World Wide Web Consortium, and they're the basis of most web accessibility law. So any laws that do have enforcement standards for website accessibility typically are going to point to these Web Content Accessibility Guidelines as the enforceable standards. As we mentioned, the Department of Justice is also using these as their proposed set of standards for what's going to be the enforceable guidelines for any sort of website compliance in the future. And typically when the Department of Justice has been involved in lawsuits around website compliance, the settlement agreements have often referenced these guidelines as part of their remediation strategy. So we're going to talk about these principles of digital accessibility. Again, we're not going to dive too deeply into this. These accessibility guidelines use the acronym POUR, P-O-U-R, which means websites should be perceivable, operable, understandable, and robust. And together, these four elements make up the overall goal of making web content accessible. And there are 13 guidelines that are grouped under each of those four principles. And, they apply to all web content that's going to be presented to a human user. So if you'll go to the next slide. We're going to talk just briefly about each of those four principles and the guidelines contained in each one. So the first one is that E for perceivable. So this means that, all of the information on a web page needs to be presentable to users in a way that they can perceive. So that would be doing things like providing text alternatives for non-text content, captions for videos and other multimedia. Make sure that content can be presented in different ways, including by people who use assistive technology without it losing its meaning, and making it easier for all users to see and hear content. Next slide. So the next principle is operable. So this means that a user can interact with the content on a website and make sure that they're able to understand the importance of and navigate around the page or the digital environment. So this is things like making sure that content is functionally available from a keyboard only, making sure users have enough time to read and use the content, making sure content doesn't cause any physical reactions such as seizures, so no flashing content. Making sure users can easily navigate and find content and that there's some consistency there, and making sure websites can be navigated using inputs other than keyboards. So different types of assistive technologies that people with disabilities might need. Next slide. So next, the U stands for understandable. So that means that making sure text is readable and understandable. Content should be able to appear and operate in predictable ways. And users should be able to avoid and correct mistakes. So that could be things like making sure it's clear on online forms, which fields are required, and if a user makes a mistake in a content field, making it easy for that person to recognize that and correct their mistake. Next slide. So the fourth principle under the Web Content Accessibility Guidelines is that content must be robust. So this makes sure that all content is compatible with current and future tools. So that means compatible with different browsers, different assistive technologies, and any other user tools that a person might be using. So it's really important for accessibility that websites are developed in a way that enables assistive technology users to access the content reliably and be able to adapt to the content. Next slide. And so the last thing I'll say about website accessibility for today's session is just to leave you with some best practices. Remember, this isn't currently, there's no currently enforceable standard under the ADA, although the ADA does apply to websites. The Department of Justice's position is firm on that. So your best practices here are going to be to make sure that your websites follow the fundamentals of being perceivable, operable, understandable, and robust. You want to have a process for checking for accessibility of your websites. You can do that both manually and with automated tools. Just remember that automated accessibility checkers can be helpful tools, but are not a replacement for real human end user checking. So you should not rely, totally on those automated accessibility checking tools. Make sure there's a way for the public, the people who are using your website, to report accessibility problems that they encounter. That way you know what to prioritize fixing and making sure that those issues are addressed. Of course, this is not a complete list of things to consider. There's lots of resources out there to help you with making your websites accessible. Again, I mentioned some training that we have available, and we've got some resources that I'll go over with you all at the end of today's session as well. So with that, I will turn it over to Chris, and he will talk you through the 2010 standards. Next slide. Oh, you're on it. You're good, Jess. Thank you.
Hello, everybody. We'll go over the 2010 ADA standards. Next slide, please, Jess. So what are the ADA standards? Well, let's say what the standards are not, which the standards, the ADA standards are not building code. Building code is separate from the standards, and building code and the standards have been harmonized so that they're very similar, but they accomplish or aim to accomplish very different things. Building code is primarily concerned with public safety and is locally adopted, and the 2010 standards are primarily concerned with basic access to facility for people with disabilities. Physical barriers represent the notion that you are not welcome here to a person with a disability, whether it's intentional or not. So the standards are really just a physical manifestation of civil rights. The 2010 standards are the second iteration of the ADA standards, which were developed by the U.S. Access Board and are enforced by the U.S. Department of Justice. These standards represent minimum criteria for basic civic access for people with disabilities, broadly speaking. Without these features, people with disabilities could not participate in society. Next slide, please. So where do the standards apply? The 2010 ADA standards apply to buildings and facilities of Title II and Title III covered entities and commercial facilities. Commercial facilities are included to require accessibility into the designs where these spaces may otherwise not be considered a place of public accommodation. If we think back to Title III that we learned a little while ago, to be a place of public accommodation, you have to be in one of 12 very specific categories. And oftentimes commercial facilities can fall out of that, but they're still required to comply with the ADA standards. These standards do not apply to facilities that are not covered by the ADA. So that would be housing facilities, federal facilities, generally speaking. And one thing that's important to note is that Title I of the ADA is not limited to the ADA standards. If we think back to Title I, remember, it's reasonable accommodation. It's what's reasonable for the employee and the employer. So when it comes to physical access, if there's a solution that's reasonable to both parties and is well beyond or, way outside of what the ADA standards represents, that's fine. That's for that individual. So just keep that in mind. The ADA standards apply to new construction and design. New construction must be designed accessibly and has very little leeway to not fully comply. Once a new facility has been certified for occupancy, it's then considered an existing facility from that point on. Existing buildings are subject to the standards for alterations. Planned alterations should comply to the current access standards to the maximum extent that's feasible and within the scope of work being performed. It's not always possible to provide full compliance with the standards in a space that was designed without the standards in mind. The standards can also be used as a benchmark for a covered entity to understand if that facility meets program access or barrier removal requirements under Titles II and III. Safe harbor is another concept that protects elements that used to be compliant with the 91 standards that are no longer compliant with the 2010 standards. This was implemented essentially not to punish an entity from complying with the original standards, where the standards then changed. This is not the concept of grandfathering, which does not exist within the ADA. The grandfathering is just, it's nowhere to be found in the ADA. It's just not a thing. So understand that. Next slide, please. So how do you use the standards? Think of the standards as a reference manual on accessibility, which is divided into several different sections. Standards can be found online at either the Access Board website or the DOJ website, which is ada.gov. The Access Board also created several ADA guides that address specific chapters and sections of the standards. These guides are much more user-friendly than the standards themselves. And they come with more detailed pictures to demonstrate the meaning of the requirements and include an FAQ section that can also be considered official guidance from the Access Board. Some basic tools that you may need if you're trying to evaluate a facility using the standards would be a 25-foot long tape measure, a 24-inch level, and a door opening pressure gauge. There are more complex tools that exist, like a digital level, or any number of things, but they exist to make the process more efficient and easier to do. But these are the bare minimum that should make it easily to spot check areas of concern with the standards. Personally, I prefer using the Access Board's website to reference the standards because it's just very easy to navigate, because they have pretty much they have a link to jump to any section within it as you're using it. It's very user friendly. Next slide, please. So what needs to be accessible in the first place? Chapter 2 of the standards is a section that outlines the scoping requirements of the ADA. Scoping is what tells you what is required to be accessible and how much of it. This section is what outlines that the ADA standards only strictly apply to fixed elements of a facility. Basically, the parts of a building that would stay in place if it could be flipped upside down. That's where the standards apply. The takeaway is that is the idea that accessible furniture cannot make up for inaccessible fixed elements. Fixed elements are what are considered permanent, and those must be designed accessibly. And you really shouldn't design permanent fixtures inaccessibly because you have movable fixtures in mind that are accessible. That's not the way the standards were intended to be utilized. There are a lot of permitted exceptions for alterations that are found in the scoping section as well. So essentially you would take whatever element you're seeking, and first you just go to the scoping section. Let's say you're looking at plumbing facilities, like a restroom, you'd find under plumbing facilities, and then you'd find the subsection. And it would tell you everything you need to know about how much needs to be accessible. Next slide, please. So what does accessibility actually mean? The technical requirements of the standards that are found in chapters 3 through 10 specifically define accessibility, minimum accessibility under the ADA. This is where you find the nitty-gritty dimensional requirements. Some exceptions for alterations can also be found in these sections. If a space is to be considered accessible, the technical scoping and regulatory requirements should all be satisfied. The ADA rarely requires that an element was required to be provided, but mostly that where elements are provided, they should be accessible to people with disabilities. So the ADA wouldn't say you need to have a urinal, but the ADA does say that if you have 2 or more urinals, 1 urinal should be accessible. Next slide, please. So chapter 3 is titled the building blocks section. These are common components of accessibility that should be included in multiple areas of accessible features. For example, floor or ground spaces can apply to accessible routes inside of a restroom or the access aisle of a parking space. Knee and toe clearance can apply at a drinking fountain or at a dining surface. Any element that has operable parts to it, like the latch of a door, will have to comply with operable parts requirements, meaning one hand operable, requiring no tight grasping, pinching, or twisting of the wrist, and also require clear floor space be adjacent to the element and be located within an applicable reach range that, within applicable reach range. Protruding objects are also found in this section, which are hazards to people who are blind or have low vision, and should be considered along all circulation paths, not just accessible routes. So these are just common accessible features that a lot of other spaces refer back to. Next slide, please. So the accessible route is the heart of accessibility, because if you can't physically get to where you want to go due to disability, you're being denied the opportunity to participate on the same level as your peers. There are several components of an accessible route, there's the accessible walking surface, which characteristics are being stable, firm, and slip resistant, free from hazardous openings and abrupt changes in levels. Doors, doorways, and gates all have requirements for accessibility as well. Interior door opening force is required at a 5-pound maximum, but exterior doors, outside doors, or doors that lead to the outside, are regulated by local fire and safety codes. So it may be more than 5 pounds in those instances. The ADA doesn't require automatic door openers, but does require independent integrated access under the general regulations. So it's up to every covered entity to decide how to best provide integrated independent access when they have a heavy entrance door. Ramps and curb ramps both have access requirements, but it's important to understand that a ramp and a curb ramp are two very different elements. They have some similarities, but also some striking differences. It'd be like comparing a horse and a zebra in that sense. Similarities exist, but they're not quite the same. Ramps are used to travel up a change in level greater than 1/2 inch, and curb ramps are used to get onto a curb. Most ramps require handrails, but curb ramps never require a handrail. Elevators can be a component of an accessible route in multi-story buildings, but so can a platform lift, which is permitted to be used to provide vertical access where an elevator is not required. Next slide, please. Accessible parking. Parking should be accessible where it's provided. Should connect to an accessible entrance, should be located on the closest or the shortest accessible route, not necessarily the shortest route. 1 in 6 accessible spaces should be van accessible. Signage is required. The access aisles should be marked to not indicate parking. And the ISA, International Symbol of Accessibility, should be used. And there are alternative designs, like this one on the right-hand side with the figure leaning forward to indicate motion. While there is a movement for that, it's not necessarily a adequate substitute for the ISA under the ADA. So all signage that is required to have the ISA under the ADA must have the symbol that is located on the left. Next slide, please. Okay, accessible plumbing elements. Drinking fountains are required to have both a high and a low unit. The high unit is also considered accessible for people who have trouble bending at the hip, whereas the low unit is considered accessible for people who use wheelchairs and those of lower, shorter stature. Safe harbor does come into play sometimes with drinking fountains because the old standards used to only require the lower unit. And it's important to understand that if you're providing a bottle filling station, it can be provided in addition just to drinking fountains, but it can't replace the high or the low because both are considered accessible. Restrooms are one of the places where there are the most instances of inaccessibility. And the biggest offender are bulky dispensers, which either if located, like in this picture along the wall, could be a protruding object where a person with low vision can inadvertently walk into that and maybe hit their head. Or if they're located under a grab bar, for example, a bulky toilet paper dispenser, that can really impede a person with a wheelchair's ability to transfer onto a toilet. A lot of people who use wheelchairs have different methods and different functionality based on their injuries, and they have preferences or ways that they need to transfer onto the toilets, and those bulky dispensers can really impede that. Next section, please. Next slide. So a quick overview of the rest of the ADA standards. It does include communication elements, which specifies the signage requirements, special rooms and spaces like assembly areas and dressing rooms. One thing that's important to note is that when you have a dressing, fitting, or locker room, a changing bench is required. The standards also have built-in element sections for dining and work surfaces, benches, which are the benches for dressing, not necessarily a park bench, and sales and serve counters, and then recreational facilities, which have swimming pools and play areas, among others. Next slide, please. And there's a couple other things to be aware of when it comes to the ADA standards. The concept of path of travel applies when you are making an alteration to a primary function area. A primary function area is basically the reason a facility exists. And the path of travel is the literal path of travel to get from a site arrival point to that function area. And what is required is that an additional 20% of the alteration to that primary function area be spent to improve the access on the path of travel to that primary function area. Under Title III of the ADA, there is an elevator exemption. Elevators are required for buildings that are three or more stories high and have at least one floor with 3,000 square feet or more. Otherwise, elevators are not required under the ADA. And this only applies to Title III entities. Title II entities, not so much. And then I mentioned this a little while ago, but qualified historic preservations have a process where the state historic preservation officer or advisory council on historic preservation has the right to determine whether accessible routes, entrances, or toilet facilities would threaten or destroy the historic significance of a building or not. It should be considered that accessibility should be considered and should be implemented unless this officer or council says that will destroy this historic significance. And that is all I have to say on the standards.
Great, we're gonna hand this over to Maggie for the next part of our presentation.
Hi, Maggie here again. Next slide, please. Service animals have a specific definition under the ADA, specifically under Title II and Title III. And you'll notice I have dog highlighted. It is any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. It can be any type of a disability. It's not limited, say, to somebody who has a visual loss. It can, a dog can be trained to ameliorate a task such as letting a person with a seizure disorder know that they are having a seizure or to get out of the way. So it's any type of disability. And the task is any task that mitigates an aspect of an individual's disability. And so really the formula for is this a service animal is that a person has a disability, they have trained their service dog, basically they are allowed access into almost anywhere. There are a few exceptions, but generally speaking, this is all that's required for an individual to use a service animal. Next slide. Go ahead, Jess. And of course, there's always an exception under the ADA. It must be a dog, but there are other exceptions that it could include a miniature horse. There are reasons for that. Many times people have allergies to dogs and can't use them. They do live longer, and so the investment is has a longer time for the person to use it. They're very alert to danger, changes in the environment. They don't easily spook, and they don't crave human attention the same way as a dog does. And so again, many good reasons why a miniature horse could be a service animal, but they must still meet the same requirements as the service dog. It must be trained to provide a specific task. It must be house trained or other cautions taken in that respect. So just be aware if someone comes in with their miniature horse, it can be a service animal. Next slide. So what are the tasks? This is the handler must train their dog to perform a very specific task or tasks. There are programs available that some dogs are able to go through, but it is not required under the ADA. So what that means is a person with a disability can train their own animal, their own dog, to be a service animal. And many times this is absolutely necessary because they are trained to understand what that individual, their need is. So be aware, there is not a specific training that they go through or a program that they go through. But the tasks must be directly related to mitigating that person's disability. The task cannot be violent. And what that means is protection can be a task in different situations, but it is not aggressiveness. They cannot be threatening to other individuals or other animals in general. So violence is not considered a task in general, but protection can be. Next slide. So how do we know what is a service animal and what is not? Under Title II and Title III, and in general, just public accommodations where people go in and out of a store, so to speak, there are only two questions that the business can make to the individual if their disability is not obvious. If someone comes in and they have a dog on a leash, you can't tell that the person has a disability, I can ask as the manager or an employee, is this service animal required because of a disability? Notice I'm not asking what the disability is. I don't have the right to ask that. Once the person says yes, then I can ask what work or task has the animal been trained to perform. Again, they do not have to disclose their disability under Title II and III, only that what the task has been, they've been trained to perform. Once they answer those two questions, they then should have access to all public areas. So wherever the general public is allowed to come, pretty much you're going to have to allow a service animal in there. You cannot charge any extra charges for having to clean up. And by clean up, I don't mean necessarily if they have an accident. That's a little bit different because they are supposed to be under the control of the handler. But this means, say, in a hotel room, they can't charge extra because they know it's going to take extra cleaning because there's been an animal in there. The care and supervision is always under the responsibility of the handler. There is no documentation, no certification required. This has gone through a couple of updates, and the Department of Justice has consistently ruled that there is no documentation or certification required. And there are different reasons for that. One being, if I self-train my service animal, then obviously there's not a certification that I can provide to myself. There is no vest required. As a matter of fact, most individuals don't want to bring the attention to the fact that they have a disability. And so there's no vest required that says service animal on it. A service animal should be tethered in some way, by leash, by hand controls. There is an exception. There are times when the task that the animal has been trained to perform, the person's disability, they can't tether them. They can't hold on. They can't keep them tethered that way. And so they can be off leash, but the requirement to be under the control of the owner is what would be important. So in other words, they may not be on a leash, but the animal should be reactive to what the handler requires of them, sit, stay, that kind of thing. So keep in mind, they should be tethered in some way. but there are exceptions to that requirement as well. Next slide. When there are questions about when you can exclude a service animal, there are times when you have to do that. If the animal is disruptive, and that can mean a lot of different things in a lot of different situations. You know, a dog will bark whether they're a service animal or not, but a consistent, constant barking can be considered disruptive, and particularly depending on what type of venue you're at. You know, a barking dog during a concert may be disruptive. So again, very individualized. If that animal is out of control, and that can mean many different things. They're running around. They are not obeying the handler. And an important part of this is that the handler doesn't take effective action to control it. So in other words, you want to give the handler the opportunity to get it under control. But if they don't, or they can't, at that point, you may be able to exclude them. If the animal damages property, this is not acceptable. If there tends to be a direct threat to health or safety, this can also mean many different things. If the animal is sick, if the animal is lunging, if the animal is threatening. If it's a fundamental alteration, and the Department of Justice has determined in most situations, it's not going to be a fundamental alteration to allow a service animal into a public area. But some examples of a fundamental alteration could be, let's say, if you've ever heard of a cat cafe, and there really is these places where people can bring in their cats and they just, you know, have a little cafe, they have a good time. Bringing in a dog into something like that would probably be a fundamental alteration, and you would not have to allow that to happen at something like that. When you determine these exclusions, they must be based on actual behavior or history, and not just fears or generalizations about how an animal or breed might behave. There is no restrictions on breeds. And so even though a local city or county might have a restriction, say against more aggressive dogs like a pit bull, if that animal is a service animal, the ADA will supersede any local laws that might be. And then you would use these exclusions to determine whether or not the animal can be there. And keep in mind too that if something happens and they do have to be excluded, you still must offer goods and services to the person without the animal present. Next slide. And just to reiterate, there's no registration required. There's no proof of disability that they have to provide to you. They do not have to have a harness or a vest, no certification. There is no paperwork. There are no ID cards, patches, documentation from doctors, or proof of training for Titles II and Title III. Next slide. Service animal in training is not protected under the ADA. And so if this animal is being trained, they are not protected. But an important thing to know is that some states have increased that flexibility, and they do allow a service animal in training. So you may need to check with state laws before you turn away a service animal in training. Next slide. Emotional support animals are not covered under the ADA. They're basically, you know, just by being there, they provide comfort. That is not a task. Companionship is not a task. Therapeutic benefits, these are not covered under the ADA. And the key here is that, again, it's not trained. It's not been trained to perform a specific task. Next slide. Be aware too, there are other laws that have different rules, and this can impact what's considered a service animal or an emotional support animal and what is allowed and what isn't allowed. The Rehabilitation Act of 1973 has a different definition. The Fair Housing Act allows other things besides a service animal or even a dog. The Air Carrier Access Act has recently been changed to follow more closely to what the ADA says. IDEA, so service animals in schools may be different. And ADA Title I, this is important to know, it's a little different. And again, that's state law. Next slide. I wanted to go ahead, be aware that under Title I, employment, there is no definition for what a service animal is. And you would go through the same process as you would for any type of an accommodation request. So it is not the two questions that you can ask under Title II and III of whether this is a service animal and what tasks has the animal been trained to perform. You must go through that interactive process to determine if it will be a reasonable accommodation. It may not be a dog, and it may not actually be what we would consider a service animal. And so it's very important that you look at and determine what is reasonable for the specific situation that you're involved in. Next slide. Just a few etiquette tips. Treat the owner, the handler, with common courtesies. Always speak to the owner of the dog and not to the dog. Keep your own dog, children, or other distractions away from a working dog, and discourage someone from attempting to distract a service animal. This is a life and death situation sometimes. Do not ever distract the animal. No food, no smooches. Don't talk to the animal. Don't assume that a napping dog is off duty or that it's fake because they're waiting on their next command. Don't confront or question somebody that you suspect doesn't have a disability. Go to the proper authorities. All right. And with that, Chris is on.
Hi, everybody. This next section, we'll be talking about the basics for transportation under the ADA. Next slide, please. So there are two sections of the ADA transportation regulations. There's service to people with disabilities, which include transportation facilities, accessibility specifications for transportation vehicles. These are in addition to the Title II and Title III responsibilities that the entity also carries. And we mentioned this earlier, but I just wanted to reiterate that ADA transportation regulations do not apply to airline travel. Airline travel is covered under a different federal law called the Air Carrier Access Act. Next slide, please. So Part 37, services for people with disabilities, ensure that non-discrimination occurs in transportation administered to people with disabilities. Clarifies that a transportation provider must not establish eligibility criteria that has the effect of screening out people with disabilities, to make reasonable modifications of policies, practices, and procedures in order to avoid discrimination, and to provide auxiliary aids and services when appropriate. They must also remove barriers to access under program access, or when it's readily achievable to do so under Title III. It also establishes standards for accessible transportation facilities, as well as requirements for each transportation entity to designate its own ADA coordinator. And that's regardless of the size of the entity or whether it's private or public. It must have a person designated to ensure that the transportation provider is adhering to the ADA. The ADA, service to people with disabilities, regulations apply to three broad categories: any public entity that provides designated public transportation or intercity or commuter rail transportation, any private entity that provides specified public transportation, and any private entity that's not primarily engaged in the business of transporting people, but does operate a demand responsive or a fixed route system. Next slide, please. So taxi services are actually not required to acquire accessible automobiles under the ADA regulations, but should otherwise not refuse to provide services to those who are able to use an automobile. A taxi provider is not required to purchase vehicles other than automobiles.
Chris, sorry to interrupt. I think we might be on different slides.
Next slide. That was probably my bad. Next slide, just thank you. Okay, sorry. So taxi services are actually not required to acquire accessible automobiles, but they shouldn't refuse service to people who can use automobiles. The provider of a taxi service is not required to purchase vehicles other than automobiles in order to have a number of accessible vehicles in the fleet, but private entities providing taxi services should not discriminate against people with disabilities, including but not limited to actions such as refusing to provide service to people with disabilities, refusing to assist with stowing of mobility devices, or charging higher fares or fees for carrying individuals with disabilities and their equipment that are charged to other people. So no surcharges, essentially. Next slide, please. Paratransit services are required to be provided as a complement to fixed route transportation services, except these requirements do not apply to commuter bus, commuter rail, or intercity rail systems. A fixed route service has fixed transit stops, locations, and operated on a fixed time schedule. This is opposed to a demand responsive system, which involves traveling to and from locations at times in response to the demand of an individual. If an individual meets the eligibility criteria established for paratransit with respect to some trips but not others, the individual would be paratransit eligible for only those trips that person meets the criteria for. Individuals may be ADA paratransit eligible on the basis of a permanent or a temporary disability. That's an interesting difference. This is the one section of the ADA where a temporary disability could carry ADA protections. Next slide, please. Paratransit services are available for people with disabilities who have a specific impairment related to condition which prevents that person from traveling to a boarding location or disembarking location within the transit system. Not simply that it's more difficult to get there. It really has to be they can't get there. Just like saying there are a public right-of-way without curb ramps would be an example. Companions accompanying people with disabilities should also be allowed to travel with the person on a paratransit vehicle when space allows, and should be charged the same fee as that person. But a personal care attendant should always be allowed to travel with the person with disability and at no charge on paratransit. Next slide, please. All information about the process, materials necessary to apply for eligibility, and the notices and determinations concerning eligibility for paratransit are required to be made available in accessible formats and upon request. If the transportation provider has not made a determination of eligibility within 21 days of submission of the application, they're required to treat the applicant as eligible until and unless the application is denied. Eligibility determination should be made in writing and accompanied by an explanation if the application is denied. A simple no is not acceptable. The provider may require recertification of eligibility for ADA paratransit at reasonable intervals of time. And the transportation provider is required to establish an administrative appeals process for those whose eligibility had been denied, where the covered entity may require the appeal to be filed within 60 days of the application. So if you're denied, there should be a process to appeal that, but they can have a due date for the appeal process to begin. Next slide, please. Paratransit services should be provided within 3/4 of a mile of a fixed route system. Within a core service area, small areas that do not meet the 3/4 mile overlap, but are otherwise surrounded by fixed route corridors should also be served. Outside of core area areas, the entity may designate certain corridors with widths from 3/4 of a mile up to 1.5 miles on each side of that fixed route, but based on the local circumstances. Trip requests should be honored if made at least the day before the trip. The entity may permit reservations to be made up to 14 days in advance of a requested trip. The reservation system should be open during normal business hours, or at least comparable to normal business hours on non-business days. Pickup times may be negotiated up to 1 hour before or after the requested pickup time. Individual paratransit fares may not exceed twice the fare of the comparable fixed route system that you would have used had you been able to use the fixed route system. The entity should not impose restrictions or priorities based on the purpose of the trip. Paratransit service should be available throughout the same hours and days as the entity's fixed route system. So it should really mirror the fixed route system in all capacities. Limitations to paratransit service should not be placed because of the number of trips requested, waiting lists, or operational patterns that demonstrate substantial numbers of untimely pickups, trip denials, or missed trips, or trips that are excessively long. Next slide, please. The entity is required to announce at least at transfer points with fixed route systems, other major intersections and destination points, and intervals along a route sufficient to permit an individual with a visual impairment or other disabilities to be oriented to their location. Additionally, they're required to announce any stop on request of an individual with a disability. Service animals must be allowed, but are not restricted to a breed of dog within the context of transportation ADA regulations. A service animal means, under the definition in transportation regulations, any guide dog, signal dog, or other animal individually trained to work or perform tasks for an individual with a disability. The entity should ensure that adequate time is provided to allow individuals with disabilities to complete boarding and disembarking from the vehicle. Priority seating and wheelchair securement locations should be provided with signage, indicating that non-disabled persons should vacate those areas so that a person with a disability or elderly persons can use those spaces. But the transportation entity is actually not required to enforce the vacation of these seats by federal law. They can institute their own policies, but the federal law doesn't force them to. Next slide, please. Buses, vans, rapid, light, commuter, intercity, and high-speed rail systems, over-the-road buses, people movers, which are automated guideway transit, ferries, and trams all have their own accessibility requirements and are covered by the ADA transportation regulations. All vehicles should provide either a lift or a ramp. All of these vehicles, again, like I mentioned earlier, automobiles of taxi services are not required. Lifts to accommodate at least wheelchair users, or excuse me, the lift is to be designed to accommodate at least a wheelchair and user combination weight of at least 600 pounds and allow both inboard and outboard facing of wheelchair and mobility user devices and use by standees. So you should be able to get in facing either direction. And if you say that you need to use it, if you're a standing person, they should be able to let you do that. Lifts should accommodate people with walkers, crutches, canes, or braces, or otherwise have difficulty using steps. 2 securement locations are required on vehicles that are longer than 22 feet, and 1 securement location if a vehicle is 22 feet or shorter. Vehicles that are longer than 22 feet that are used in multiple stop fixed route services are required to be equipped with a public address system that permits the driver or a recorded or digitized human speech message to announce stops and provide other passengers information within the vehicle. And then a stop control is also required to be located next to a securement location to notify the driver that mobility aid user is requesting to stop. This system should provide auditory and visual indications that the request has been made. And next slide, please. This is one thing I wanted to note is that on July 5th and 6th of 1978, a group of disability activists known as the Gang of 19 surrounded 2 RTD buses in downtown Denver, Colorado. So this is pretty unique to our region. It's pretty interesting that such a big movement started in our region. These people were part of a group known as ADAPT, which stands for the American Disabled for Attendant Programs Today. These 19 people were wheelchair users that were protesting the lack of access in public transportation, which was triggered by RTD ordering 250 new city buses where none of them had a wheelchair accessible lift, and all of them were inaccessible to wheelchair users. In 1985, RTD became the first metropolitan region in the country to provide wheelchair accessible service on all local buses. And this is before the ADA was enacted. In 1990, the ADA was passed that required transportation to be accessible and usable by people with disabilities. ADAPT was a political wing of what is now today the Atlantis Community, which is the Center for Independent Living that operates in the Denver metro area. And it's just a very unique aspect of the historic aspect of transportation originating within our region. And with that, I'll pass on the baton to Emily.
All right, well, thanks a lot. And we are getting towards the end here, getting towards our wrap up. I know we have covered a whole lot of information in today's ADA Basics course. We are going to have some time at the end for questions. So please, if you haven't already, submit your questions in that Q&A section so that we can address some of your lingering questions. Just a couple of reminders here. We will be emailing both the slides and the recording of today's session to everyone who was registered for this session, so you'll get that automatically. We'll also be posting the recording and slides on our website, and we'll be posting the recording on YouTube as well. So just in case you feel like you missed some pieces or parts or didn't retain everything, we certainly will be providing access to this so that you can go back to it at any time. Just another reminder, please do email us for a training certificate. We will put the email address in the chat again as a reminder, and you can also find it in several places on the slides. Next slide. So I know you may have lots of questions. I just want to again reiterate that whether or not you're in the Rocky Mountain region or attending from elsewhere in the country, you do have access to a regional ADA center. Please contact your local center if you don't get your question answered today or you feel like you need some additional information. Remember that the number for every ADA center is 1-800-949-4232. You can also find more information about your local ADA center at adapa.org. Next slide. So some great resources for additional information. We always like to point people to ada.gov. That is the official government website, federal website for the ADA. That's not only where you can go to file complaints, get information about filing a complaint of discrimination, but there's also lots of helpful guidance and resources available right there on that website. I mentioned the ADA National Network. Again, great resource for anyone who just needs more information about their rights and responsibilities under the ADA. Our center, I've listed our website here, RockyMountainADA.org, if you happen to be in our region and want to connect with us directly. I know that Maggie, specifically for that employment portion of the ADA, already mentioned the Job Accommodation Network. So they focus real specifically on accommodating, all of the regulations for accommodating employees with disabilities, and have lots of great resources for both employers and employees on how to do that. I know Chris mentioned the U.S. Access Board. They are the, of course, they're the authors of the 2010 ADA standards. They also provide technical assistance and training. So that's another great informational resource. If you have a question about a housing situation, we would typically refer you to HUD, the Housing and Urban Development Department, through Fair Housing Accessibility First. That's another great informational resource. And then if you want to know more about website accessibility, there's a link on the slides here to the web content accessibility guidelines that I mentioned. Next slide. So if you're looking for assistance with advocacy for someone to, provide assistance to you on your behalf as a person with a disability, there are a couple of good resources here. We've mentioned Centers for Independent Living. And so the first link here is a directory of all of the various Centers for Independent Living that you can find the one that applies to you in your local area. They have lots of great peer support and advocacy type services. There's also organizations called protection and advocacy agencies, which do some advocacy work, and they can also do some legal work on behalf of people with disabilities. So the link here again is a directory where you can find your local protection and advocacy agency. The ARC is another great resource for advocacy, specifically for people with intellectual and developmental disabilities. So this link here will also help you find your local chapter of the ARC. You can also connect with the American Association for People with Disabilities, as well as the National Disability Rights Network. Next slide. And so getting to enforcement, if you're in a situation where you feel like you've been discriminated against on the basis of disability in any of the areas that we've talked about today, you can contact your local state civil rights office. So there's a link for the directory of those offices here. You can also file a complaint directly with the Department of Justice for those Title II and Title III complaints. In issues. Similarly, you can file a charge of discrimination with the Equal Employment Opportunity Commission if it's a Title I employment complaint. You can file complaints with the U.S. Department of Transportation if you have an issue with air travel. So they would be the enforcers of discriminatory treatment under the Air Carrier Access Act. And then for housing, you can report an instance of housing discrimination, again, directly with that Housing and Urban Development Department. Next slide. So just some final thoughts for you all, and thank you so much for hanging in here with us for this 4-hour training. Final thoughts before we get to questions. Remember that ADA compliance is not just a checkbox. It really is an investment in our collective success. When we're able to remove barriers and tap into the full spectrum of abilities, that actually leads to a more dynamic and economically robust society. Along the same lines, recognizing and leveraging the unique strengths of people with disabilities creates a stronger, more resilient community. And being inclusive really benefits all of us, not just for a few people. It really benefits everyone, not just people with disabilities. And finally, as we do this work to break down barriers, we're actually having the effect of elevating everyone. Celebrating diversity isn't just about compliance. It's really a journey toward shared progress, where every individual's contribution adds value to the whole. Next slide. So again, remember, we're here to help. This is the direct contact information for the Rocky Mountain ADA Center. And from here, again, we'll thank you for your time. And if you'll go to the next slide, we will take some questions.
Great. I'm just gonna read from the top of the list, if that's okay. Just a second. Oops. Trying to pin myself so everyone can hear me. A question from a while back. Question is, what is an example of job restructuring and what does that look like?
Hi, this is Maggie. An example of job restructuring, again, it can be very flexible. Let me think of one. It could be, gosh, my mind is going crazy because there could be so many different examples. So give me just a second. Sorry. Restructuring can involve giving nominal or sorry, not nominal, but non-essential peripheral job functions to someone else, or at least taking it away from that individual. That's one thing. Restructuring can be maybe altering the hours that a person works. Maybe their transportation is only available at certain times, and so they can't be there at 8. So maybe we restructure it and have it come in at 9 or 10, depending on, again, a lot of different things. Those are the first couple of things that I can think of. I know Job Accommodation Network has some really good examples on there. And if you go to their website, askjan.org, there's a lot of things in there that you can look up too.
Great. Thank you, Maggie, for answering that question. Our next question. An healthy person was hired and had injured during regular job performance, for example, standing for 8 hours. Should that employer provide the accommodation to this employee? Or can that employer just say that you should not come back until you are fully recovered from the injury? Is that illegal to say that?
In general, it is illegal to make a blanket requirement that you go home and you don't come back until you get fully recovered from the injury. First of all, the individual should let the employer know that they may need an accommodation, and then once they're known to need that, then yes, the employer should consider what the accommodation request is, and then go into that interactive process to determine what's going to be effective and what's for both the employer and the employee. Generally speaking, now there may be a time where there are no accommodations that will enable the individual to do their particular job. And so you might at that point look at time off. That is a form of accommodation, but it should not be the first form. It should be that we look for accommodations that will enable the individual to do the job, so that they can continue to, to bring home a paycheck. That's why we work. So definitely making a policy about don't come back until you're fully recovered. You need to look at ADA accommodations that might be available.
Great. Thank you, Maggie. Go back to another question. Next one says, what does or can the process look like if an individual gains a medical condition during employment that prevents them from being able to conduct essential responsibilities of that role and would like to find an alternate role in the company they can do?
Reassignment is, again, another form of accommodation. You go through that interactive process to help determine what's needed, what are the limitations, what the job entails, what's needed. And if there's not an accommodation that would allow the person to continue to do the functions that they're in right now, you definitely can look at reassignment. You do not, an employer does not have to create a position. And so they would look to see what is available, what the person is qualified to do, and trying to find an equal job, equal pay, benefits, that kind of thing. Now, the ADA does allow that if there's not an available reassignment position open that is, say, equal, that it does pay less, that is acceptable. It should be more of that last resort thing. But there are situations where there's just not any position available. And so, you can offer the job, the reassigned job, to the individual. They have the right to say, no, I can't live on this. But at that point, the employer has probably fulfilled their responsibility to provide an accommodation.
Great. Thank you, Maggie. Another question. Most applications have a section where they ask you about having disabilities. I know people that didn't want to disclose their disability for fear due to not being considered for the job. What do you advise to those individuals?
What I can't really advise, to be honest, because that's I can only tell you what the ADA requires or doesn't require, and then each individual does have to try and determine how they will react to each individual situation. But in general, an application should not ask about disabilities, with a couple of exceptions. Some employees are actively seeking individuals with disabilities, affirmative action type thing. And so in situations like that, they can ask, do you have a disability? What that employer, that application should say is something along the lines of, the reason we're asking this is because you will get preferred treatment. Otherwise, so there are a few exceptions, but in general, until the individual has done the application and has gone through an interview, and through that process is determined that with or without an accommodation, the person can perform the essential functions, then they just do not have to disclose. But again, this is a very personal issue as well. Some people feel like I have to tell them right away, because I feel like I'm hiding something if I don't. And, but the ADA, the legal portion of that is that the ADA tells you you don't have to discuss it until that particular time. So And again, I'll refer you back to Job Accommodation Network. They have some wonderful, many different resources on disclosure and things to think about. Because again, it is an individualized decision on when to disclose.
Thank you, Maggie. Another question. Bringing a dog to work or a store. When or how can we get a law requiring certification for a service dog? For instance, an emotional therapy dog is not covered under the ADA, but persons are now buying vests online and claiming their dog is. How can we make sure an employee or patron does in fact need a service animal?
And hopefully some of that was answered through the presentation given earlier. These are issues. This particular question, we're talking about two different issues, really. In employment, that's a Title I, and so you go through that interactive process. And if you remember, we discussed that it's much more flexible under Title I. And so an employee who has requested a service animal or even an emotional support animal as an accommodation, you have to sit down and go through that, that process. What are the needs? What are the limitations? Is this going to be reasonable to have this particular animal in our particular facility? Some places it might be okay, some places it might not be okay. So but for in the employment portion, you can require documentation that there is a major life activity there that is that needs a an accommodation of the animal. But Title II and Title III, the Department of Justice has looked into this several times, and it actually did make some changes from the original law that was very broad and allowed all kinds of different not just animals, but reptiles and things to be service animals. They did close that in and make that more specific to dogs, with the exception of a miniature horse. Emotional therapy dogs are not covered. And you are right. Anyone can go online and order a vest and claim that the dog is a service animal. And there's not really a good answer to what you I think what you're asking. I don't think Department of Justice will ever change that it requires certification, because again, that has always been a major area of conversation when discussing service animals. Let's see, where did sorry, I
Maggie,
was looking.
may I add one thing about that as well?
Sure.
The ADA, I mean, go back to the ADA as being a civil rights law. The last thing that Congress intended to do with implementing the ADA was require things that were similar to, you know, if you go back to the World War II area and the Nazi occupied Germany, where people of Jewish descent were required to bring papers to participate in society. The ADA does not want to mimic those practices. So that's a big reason why certification of service animals is not required. It's too similar to requiring your papers to participate.
Mhm.
Great, thank you. Another question. Maybe I didn't fully understand about people with disabilities not having to report to the employer that they need accommodations until they are hired. What if it's someone that has like a 30-pound lifting requirement and the employer didn't tell them that they have to lift until after they are hired?
And this this goes back to that process again of determining once an individual has gone through the application process and the interview process, and now we're getting into, we've offered the job, now we can discuss what limitations an individual may have. And so even an individual who might have a 30-pound lifting requirement, it is, first of all, is that an essential function of the job position they're being hired for? And then secondly, are there accommodations that would still allow them to do it? And this goes back to looking at not necessarily how it's done, but that it gets done. So what that means is there can be an accommodation that would allow the individual to be able to do that. So it is very, the person does have to perform the essential functions of the job, but they may be able to do it with a disability, with an accommodation. So this is where you get into that interactive process again, to discuss what are the problems, what are the issues. Now, once a job has been offered, you can't take it back just because a person has a disability or that you have to provide an accommodation. But you do then look at, is there an accommodation available? Can the person do this job with an accommodation? They may not be able to. And again, that's where you would, at this point, make determinations on whether or not the person is truly qualified to do the job.
Great, thank you, Maggie. And we have one last question. What are the basic requirements of notice regarding compliance with ADA that must be posted? Sorry if you have already answered this, but I need this in a nutshell.
Well, I can start on that. Under Title III, there are no requirements for posting notice. Under Title II, there is a small notice that I'm trying to find, but it has to do with the self-evaluation. It's only where the entity has 50 or more persons that they employ and has performed a self-evaluation. That self-evaluation should be made available for public inspection for a period of 3 years following the completion of the self-evaluation. But other than that, that's really the only specific behind that. Under a transition plan, the transition plan should be part of, or public input should be part of that process of creating a transition plan. So it's implicit that it's supplied during that process. But other than that, it's not necessarily required. Maggie, is there any stipulation under Title I for ADA postings to be made that you know of?
Under Title I, other than the employment laws that the EEOC requires about your civil rights, other than that, which does include under the ADA, you are supposed to have, an acknowledgement that you have rights under the ADA. This is who you would contact. That's all I can think of for Title I.
One other thing I can think of, it's not necessarily a notice of compliance, but when it comes to physical accessibility, where an entire facility is not accessible, let's say there are public entrances that are not accessible, signage should be placed to direct people to accessible locations or accessible entrances. And they should be placed in areas to minimize backtracking. But that would be only required where, again, like I said, not every entrance is accessible, or let's say not every restroom is accessible, but you have a facility where there's a nearby restroom that is accessible. You would be required to put signage near the inaccessible element to direct people to the accessible element, and then identify the accessible restroom with the international symbol of accessibility. Otherwise, you're just looking at the signage requirements, which aren't necessarily notices of compliance.
Great. Well, that was the very last question that we had. Is there anybody else that might have another question like to ask right before we leave? Okay, well, thank you to our amazing interpreters. Yes, thank you very much for all you do. Well, that puts us right at 1 p.m. So thank you all for all of those that attended today. And remember, please don't hesitate to follow up with your local ADA center if you have any additional questions. And another note that we'll be posting this webinar and presentation material in the upcoming days on our website. And have a great rest of your day. Thank you.
Risha, it looks like Jess left. Are you able to end the webinar?
Sure, I was just going to ask you that. I'll go ahead and end it for you.
Thanks so much.
Bye-bye.